The House Committee on Elections will come to order. Members, I have a favor to ask as we're both doing roll call and speaking, if you can make an effort to speak in your mic. In the audio last week, some of your voices weren't picked up, so if you can be purposeful of that. With that request, the clerk will call the roll.
Chair Shaheen.
Here.
Vice Chair Busey.
Here.
Representative Isaac.
Here.
Representative Morales-Shaw.
Present.
Representative Plesa.
Here.
Representative Raymond.
Here.
Representative Swanson.
Here.
Representative Toth.
Here.
Representative Terry Wilson.
A quorum is present. Follow my own advice. As a reminder, anyone present wishing to testify before the committee, please register at the kiosk located in the hallways behind the hearing rooms. If you require assistance in registering or testifying, please contact our committee staff. Due to the number of witnesses who have registered and to accommodate all who wish to testify today, there will be a time limit of 3 minutes per witness during the public testimony. Please try to be within those 3 minutes. I'm very shy and don't like to cut people off, so help me out with that. Committee members, as a reminder, please remember to check out the publicly available comments. These comments are left by the public on each agenda item in our hearings. Comments are open until the end of our hearing and are posted upon adjournment for our hearing. With that, members, we will now vote out several bills, which we have heard in the previous hearing. Chair lays out HB 640 by Baumgardner as pending business. Members, this is the bill we heard previously relating to the office hours of election authority during an election period. The chair moves that HB 640 without amendment be reported favorably to the full House with the recommendation that it does pass and be printed. The clerk will call the roll.
Chair Shaheen.
Yes.
Vice Chair Busey.
Yes.
Representative Isaac.
Yes.
Representative Morales-Shaw.
Yes.
Representative Plesa.
Yes.
Representative Raymond.
Yes.
Representative Swanson.
Yes.
Representative Toth.
Yes.
Representative Terry Wilson.
There being 8 ayes, 0 nays, the motion prevails. Chair lays out HB 657 by Vice Chair Busey as pending business. Members, this is the bill we heard previously relating to the requirements for counties posting election information on an internet website. Representative Plesa moves that HB 657 without amendment be reported favorably to the full House with the recommendation that it does pass and be printed. The clerk will call the roll.
Chair Shaheen.
Yes.
Vice Chair Busey.
Yes.
Representative Isaac.
Yes.
Representative Morales-Shaw.
Yes.
Representative Plesa.
Yes.
Representative Raymond.
Yes.
Representative Swanson.
Yes.
Representative Toth.
Yes.
Representative Terry Wilson.
There being 8 ayes, 0 nays, the motion prevails. Chair lays out House Bill 665 by Vice Chair Busey as pending business. Members, this is the bill we heard previously relating to the Secretary of State posting on the Secretary of State's internet website database containing certain information about elections. Representative Raymond moves that HB 665 without amendment be reported favorably to the full House with recommendation that it does pass and be printed. The clerk will call the roll.
Chair Shaheen.
Yes.
Vice Chair Busey.
Yes.
Representative Isaac.
Sorry, what bill is this again?
This is 665. This is the information posted on the Secretary of State's internet website.
Aye.
Representative Morales-Shaw.
Aye.
Representative Plesa.
Yes.
Representative Raymond.
Yes.
Representative Swanson.
Yes.
Representative Toth.
Yes.
Representative Terry Wilson.
There being 8 ayes, 0 nays, the motion prevails. Chair lays out House Bill 677 by Diala as pending business. Members, this is a bill we heard previously relating to the restrictions on political activities of county elections administrator. Representative Toth moves that HB 677 without amendment be reported favorably to the full House with the recommendation that it does pass and be printed. The clerk will call the roll.
Chairman Shaheen.
Yes.
Vice Chair Busey.
Yes.
Representative Isaac.
Yes.
Representative Morales-Shaw.
Aye.
Representative Plesa.
Yes.
Representative Raymond.
Yes.
Representative Swanson.
Yes.
Representative Toth.
Yes.
Representative Terry Wilson.
There being 8 ayes, 0 nays, the motion prevails. Chair lays out House Bill 429 by Chair Guillen as pending business. Members, this is the bill we heard previously relating to the reading and marking of a ballot by a person occupying a voting station or by the person's child. The chair offers a committee substitute that varies only that it's a legislative council draft. Is there objection to the adoption of the committee substitute? The chair hears none. The substitute is adopted. Chair moves that HB 429 as substituted be reported favorably to the full House with the recommendation that it does pass and be printed. The clerk will call the roll.
Chairman Shaheen?
Yes.
Vice Chair Busey?
Yes.
Representative Isaac?
Yes.
Representative Morales-Shaw?
I haven't seen the substitute. Is it in the?
He said it's the same, this
Okay.
council.
Okay,
Representative Plaza?
Yes.
Representative Raymond?
Yes.
Representative Swanson?
Nay.
Representative Toth?
Yes.
There being 7 ayes, one.
Representative Terry Wilson?
Now there being 7 ayes and 1 nay, the motion prevails. Chair lays out House Bill 496 by Representative Swanson as pending business. Members, this is the bill we heard previously relating to the ballot option to not vote for any candidate. The chair offers a committee substitute that addresses the proposition issue that was raised during the committee last week and includes an abstain from vote option. Is there objection to adoption of the committee substitute? The chair hears none. The substitute is adopted. Chair moves that HB 496 as substituted be reported favorably to the full House with a recommendation that it does pass and be printed. The clerk will call the roll.
Chairman Shaheen?
Yes.
Vice Chair Busey?
Yes.
Representative Isaac?
Yes.
Representative Morales-Shaw?
No.
Representative Plaza?
Respectfully, no.
Representative Raymond?
Yes.
Representative Swanson?
Yes.
Representative Toth?
Yes.
Representative Terry Wilson?
There being 6 ayes, 2 nays, the motion prevails. Thank you, members. With that, we'll start hearing bills. The chair lays out House Bill 34, or wait a minute, I'm sorry. Chair lays out House Bill 631 and recognizes Representative Swanson to explain the bill.
Thank you, Chairman Shaheen and members. Sorry, 1 second there. Okay. Home rule municipalities in Texas have fairly broad discretion when placing initiatives before voters for consideration. However, there is little uniformity in the processes used due to local elections being governed by each municipality's charter. The Texas Supreme Court ruled in Reynolds Land and Cattle Company versus McCabe way back in 1888 that the language of ballot questions must be, quote, substantially submit the question which the law authorizes with such definiteness and certainty that the voters are not misled. The court reaffirmed the decision in the Dacus versus Parker decision in 2015. House Bill 631 codifies that standard. In the 2015-2016 election cycle alone, the Texas Supreme Court decided unanimously to reprimand the city of Houston 3 separate times for using misleading language on their ballots. We need a third party unaffiliated with the local government that is presenting questions to voters to review language in advance of an election. This would prevent costly, lengthy court cases, therefore saving taxpayers money. A professor from the University of Berkeley wrote an op-ed in the New York Times pointing out that many ballot initiatives are purposely misleading and discussing how there is an entire industry around writing misleading ballot measures and campaigning. House Bill 631 will allow voters to submit suspected misleading language to the Secretary of State for review. If the SOS decides the ballot language is defective or misleading, they could require the city to resubmit proposed language. If the city fails to correct the defects the next time, the Secretary of State would have the authority to write the language. I will note here, there is no significant fiscal impact anticipated. Under the bill, a voter could seek a writ of mandamus in court to compel a local government to submit the ballot question with definiteness and certainty. In this case, a complainant could be awarded attorney's fees and court costs. If a city is guilty of violating this law in court, they would be required to submit their ballot language to the SOS for any proposition for the 4 years following the judgment. The second thrust of the bill fixes issues with petition drives that cities are using to kill citizen petitions for referenda. The following are things that this bill would do. It ensures poor handwriting is not a basis for throwing out a valid signature. It requires the SOS to prescribe standardized forms and procedures and protects the validity of petitions if cities choose not to use the prescribed forms. It allows for citizens to use their own forms as long as they contain the information required in the official forms. Cities would be required to validate the petition and signatures within 30 days of receipt. The bill puts the standard for the number of signatures required to 5% of registered voters at the last municipal election, or 20,000, whichever is lower. This is about transparency, accountability, and good governance. This bill has made it to the floor twice. In 2021, that I authored, and in 2023, authored by Senator Betancourt. In both instances, there were caption issues that allowed a point of order. I've worked closely with Senator Betancourt and the parliamentarians to ensure that the caption is correct for this bill. Thank you, Mr. Chairman and members. I'm happy to answer questions and respectfully request my right to close.
Thank you, Representative Swanson. Members, any questions for Ms. Swanson? Mr. Vice Chair Busey?
Thank you, Mr. Chairman. Thank you, Representative Swanson. I want to make sure I'm reading this right. Is this going to say that you no longer, in some areas, you have to be like a citizen of that community? So if it's a city resident come in to do the petitions, this is saying anyone can come in, they don't have to be a voter, taxpayer of that community to do these petitions now? I'm specifically looking at page 6, line 25 and 26, collector requirements prohibited. A city may not restrict who may collect petition signatures. So I just want to make sure I'm understanding that someone from outside of that community come in and lead the charge on these petitions now.
That has not been an issue that has come up, and no one has ever expressed a problem with that. You're on page 6?
Yeah, page 6, the last two lines, 25, 26.
Okay.
And we can ask Secretary of State maybe after this and then come back to it. My real concern is that, if I'm understanding it right, we're going to now allow for outside people to come into your city, do petition. I go to your city because I want to change something in your city, and I'd be allowed to do that. Where a lot of these places, it's a hashtag like. And what's the shocking statistic? No.
Hopefully it's related to the bill.
So that's, I guess, one of the flags I have here is I want to make sure that we're not saying outside people get to come control your city or my city's stuff, that it's the taxpayers and the potential voters and citizens of that community. And so maybe we get clarity if that's what it's doing. I was just curious if that was your intent with that.
That was just, it was not an intent that I had, but I would like to hear from the Secretary of State about it.
Sounds good.
Whether that's really
Yeah.
a change. Okay.
Okay, thank
All
you.
right, thank you.
Mr. Speaker? I mean, Mr. Chairman.
Are there,
Yes.
Ms.
Mr.
Morales-Shaw?
Yeah. I like your bill, Rep. I believe that the problem of putting misleading information on ballots is universal. I think that they're often worded in a way that the public thinks they're voting for one thing, but they're really voting for the opposite. So I do think it's an issue that warrants review. I have a problem with taking away the power from locally elected officials and putting in the hands of the state when the public voted for those officials to do that job. So I want to express that, but I also hope that there is a possibility in your bill for having a third-party referee that's local to every county that we're talking about. so that they retain their elected position power. But I like the bill, and I think that it's a universal problem. I think we all find that, and if there's a third party that uses a reasonable person understanding standard and says, okay, I read this and I know what I'm voting for, that's a good thing, because more often than not, it is worded in a way that's actually contrary to what people think they're voting for. So thank you for bringing the bill, and I
Yes.
hope we can talk about that issue.
Thank you. Yes, we do feel like the proper person to do that would be the Secretary of State's office, that they would ideally be that neutral party. And I see Ms. Adkins smiling over there, and we all trust the Secretary of State to handle this correctly, and I think that would be great.
Members, any other questions of the bill author? With that, we'll proceed to testimony. The chair calls Ed Johnson.
He's here. He's having to share time with the Senate here.
They're
Sir-
rearranging the furniture over there, so I had time to come back.
Sir, we show you registered as Ed Johnson on behalf of Harris County Ballot Security and yourself. And you'll be testifying for the bill.
For the bill.
All right,
Correct.
please proceed.
Great bill. Numerous times in Houston have seen these petition items where they're putting things on the ballot that the language on the petition does not end up being the language on the ballot. So this bill would actually correct that and make sure that what people are saying that they were petitioning for actually is what gets to be put on the ballot. And sometimes the chartering organizations that are making this ballot language will make it very confusing as opposed to what was on the petition. So this keeps it pretty straight. Be nice, clear language. Great bill. Thank you.
Members, are there any questions? Thank you, sir. Members, are there any questions for the witness? Thank you, sir.
Thank you.
I think we want a resource witness, so the chair calls Christina Atkins. Hello, ma'am. I show you registered as Christina Atkins on behalf of the Secretary of State's office, and you are testifying on the bill.
Yes, sir, that's correct.
Okay, thank you. Please proceed. Or actually, recognize Vice Chair Busey.
Hey, Mr. Chairman, first to the point we were just talking about, on page 6, line 25 and 26, I'm reading that as now, my understanding is some areas require, if you want to do a petition, you have to be a resident of that community. I'm reading that this would take away that their ability to have that requirement where it's local people working on local issues. Is that how you interpret it?
Actually, sir, I'm not familiar of any current laws that are on the books that would restrict who can circulate a petition, that it's restricted to the residents of that particular territory. There could be some old city charter provisions, but it would be very old city charter provisions. I think it's prior to 1985 that if they have that in the city charter would apply. But I don't know that this is, I don't know that there's anything in current state law right now that would restrict a petition circulator to somebody that resides within that territory.
Okay. Well, thank you. My other question is, can you just talk about your current role, the Secretary of State's current role, because this will change it. So can you clarify your office's current role in ballot propositions and oversight under existing law, and what happens in that process, and if there is a conflict, how is that resolved under current law, and then explain, I guess, how this would now be changed under this law?
Yes, sir. So under current law, we don't have a role when it comes to the determination or the formation of any type of ballot language or ballot proposition. Many propositions that are out there, those that are set by statute, those that are generated through different special laws, will have very specific language that needs to be there. Oftentimes, city charters, when they have an election that's either related to a charter amendment or some kind of particular issue in the charter that authorizes some kind of petition-initiated election, many of those city charters will have some kind of parameters or description in there that provide some guidelines on that language. We're not involved in that process currently. We don't currently interpret city charters, and so this is not something that we've had a role in before, but under this particular bill, we would be able to be brought into the process should any individual within that territory have or have a desire to challenge that petition.
Are you
or
able to-
challenge that proposition
Are you able to
language.
speak to what the current process is? If there is a dispute, what happens now under current law?
Under current law, if there's a dispute, that's usually initially taken up with the entity that's having the election, and then it would eventually go to court.
Okay, so so there is an option still right now to deal with those disputes under current law.
Yes, I think that's really the only option right now, is to
Let's
go
see
to
other
court.
courts. Okay. Thank you, Mr. Chairman.
You bet. Members, are there any other questions for the witness? Thank you, ma'am, for your testimony.
Thank you.
Is there anyone else that wishes to testify on, for, or against House Bill 631?
Thought I signed up. Thought I did.
Would you like to testify, ma'am? Yes, please come.
Thought I signed up. Sorry about that.
You did sign up? Hold on.
Thought she did. Thought I did.
She just,
I hope all of them got captured. You signed up for me. Sorry. Do you have me signed up for other ones?
what's that?
Do you have me signed up for other ones?
We can only talk about this bill, but if you
I know.
could register up.
I just want to make sure they went through.
If not, we'll take care of it.
Okay, got it.
Okay. Hello, ma'am, I show you read? Oh, yeah, hold on, we're having one technical
I'm
issue.
sorry. Okay.
Everything was running smooth till I got here.
Let the record show Chair Wilson is present.
We do again? I didn't go and take in. Oh my gosh. Yeah. slower here. Okay, I think we're there.
All right, so the chair calls Laura Presley. Ma'am, we show you registered as Laura Presley on behalf of True Texas Elections, and you are testifying for the bill.
Yes.
Okay, thank you.
Thank
and
you. Thank
please
you for your
proceed.
patience.
No problem at all.
Yes, Representative Swanson loved the bill. I don't know how many times I have sat there and voted for or against propositions or measures, and there's double negatives in the language that you have to go back and do some algebra. Negative means a positive. You know, that's how I do it. You know, 3 negatives is a negative. So I really have to do that math in my head. It's just very confusing. Hopefully, you know, the Secretary of State can help with all that. So my question is, and this is the reason I'm speaking on this, is it your intent that the communications back and forth between the county and the SOS would be subject to the open records request? Because the SOS is not acting as an attorney.
We actually ran into
Can
this
I-
last time, and
can I
I don't
We did.
think I'm
interrupt just for-
allowed to
Yes.
get questioned by a
Okay.
witness.
This is my question. I
Yeah.
know, yeah, we did this last time, and I want to correct.
You are open and available to provide testimony. If you have
Okay.
questions of the bill author, it might be more productive if you do that.
Okay.
If that's all right.
Okay, so my
What we don't want to happen is dozens and dozens of people come up and, which our expectation is testifying and they're quizzing the committee. You see what I'm
yes,
getting at?
yes, I hear you.
Is there any testimony that you'd like to
My
provide?
testimony is that I am concerned about there being, this being an open records, that the communications between the Secretary of State and the county would be subject to the open records request because the county is not a client of the Secretary of State, and that is an exclusion in the open records, Chapter 552. So I think it would be helpful if the bill could specify that this would be subject to the open records.
Okay.
That's it. Did I fix that?
Yes, you did.
Okay.
Ms. Swanson is a very nice member, and
Yes, and I'm
sure
here
she
if
will
there are
meet
any
with you.
questions or comments.
Yeah. Thank you for your testimony. Members, are there any questions for the witness?
Thank you.
Thank you, ma'am, very much. That's everybody. Is there anyone else that wishes to testify? Sure, absolutely. Yeah. The chair calls Christina Atkins. Ma'am, I show you registered as Christina Atkins on behalf of the Secretary of State's office, and you are testifying on the bill.
Yes, sir, that's correct.
Thank you, ma'am. Please proceed. Thank you for coming up.
Of course.
Could you address the concern that the previous witness had? Just let us know. I'm interested too.
Well, I mean, we wouldn't be acting as the attorney for the entity that's, for the entity that has the petition or the petition gatherers or the city itself. So I don't know that any of those communications would be subject to being withheld under the Public Information Act.
Okay. All right. Thank you.
Sure.
Thank you. Members, any other questions? Thank you, ma'am, very much. Is there anyone else that wishes to testify on, for, or against House Bill 631? If not, the chair recognizes Ms. Swanson to close on the bill.
Thank you, Chairman Shaheen and members. Thank you, Chairman Shaheen and members. This legislation ensures complete transparency in voter-led initiatives and in city government. I request favorable passage. Thank you.
Thank you, Representative Swanson. If there's no objection, the bill will be left pending. Is there objection? The chair hears none. The bill is left pending. Chair lays out House Bill 1477 and recognizes Representative Swanson to explain the bill.
Thank you, Chair Shaheen and fellow members of the committee. Under the Texas Election Code, the presiding judge at an Election Day polling location is required to deliver the election records immediately after the precinct returns are completed. The election judge is required to notify the general custodian of election returns if the records will not be delivered by 2 a.m. the day following the election day. In that event, the election judge is required to call the general custodian and notify them of the number of voters who voted at the polling place, the total tallies for each candidate, and the measure, and expected delivery time of the records. In no event shall the election precinct records be delivered later than 24 hours after the polls close in each election. Harris County, for example, has experienced numerous elections where the election records from the polling place were not accounted for until the day following the election day, or in some cases even later. The counting of election results has been significantly delayed, and in some cases the results have not been reconciled even when they were eventually turned in. A great example of this is the primary election in 2022, where Central Count did not complete its work until 2 a.m. Thursday, 2 days after Election Day. Situations like these weaken the perception of our safe and secure elections across the state. More and more individuals find themselves skeptical of the integrity and legitimacy of our elections, and precincts that are unable to complete and submit their returns in a timely manner add to these concerns. House Bill 1477 would provide added oversight to the collection of precinct returns. The bill allows the Secretary of State to supervise the activities necessary to complete the count, prepare the election returns, and distribute the records. In areas like Harris County, this added oversight would ensure those election returns are prepared and completed in a timely manner. It would also improve the general perception of our elections in Texas, with voters knowing that the organization tasked with monitoring our elections is personally involved in these instances. House Bill 1477 also requires a district judge to supervise these activities in the event that the election records are impounded. Again, in far too many instances, election records are not prepared and delivered in a timely fashion, and requiring the district judge to personally supervise these activities adds an extra layer of support that is sorely needed. Lastly, House Bill 1477 raises the penalty for a presiding judge who fails to include the applicable information required in the precinct returns or fails to complete the returns before the prescribed deadline. As the law is currently written, that penalty is a Class B misdemeanor. House Bill 1477 would increase that penalty to a Class A misdemeanor, providing a higher penalty for a presiding judge who does not fulfill their obligations in a timely and correct manner. Ensuring the timely and accurate delivery of precinct returns is vital in showing Texans that our elections are conducted with transparency, efficiency, and integrity. The changes outlined in House Bill 1477 help move us closer to that goal. Thank you, Chairman Shaheen and members. I'm happy to answer any questions you have, and I respectfully request my time to close.
Thank you, Ms. Swanson. Members, are there any questions?
I'll ask.
Ms. Morales-Shaw?
Yeah, so I just have a couple of clarifying questions on the bill. You mentioned that it would raise the penalty for precinct judges if they don't comply with the new law from a Class B to a Class A. And my question is, does your bill provide for a situation where there are circumstances that are beyond the control of the precinct judge? Because we've seen, because of a lot of the changes that have come down in the last couple of election cycles, we've seen that they've had to make new adjustments. We've seen equipment go down because it's electronically driven. And we've seen polls either not even open or close, stay closed or close early because of equipment failure. And so I'm wondering if your bill makes some exceptions for precinct judges, because obviously we greatly value the work that they do, and they're usually dedicated for decades to this kind of election work. I don't want to create a burden on people who want to be precinct judges for fear of a law that doesn't make exception for things that are beyond their control. That's my first question.
And that's an excellent question. Thank you. It absolutely does. And if you also look at the timeline, they have till 2 a.m. to even contact their election authority in their county and say, hey, here's what's going on, I'm having trouble. And at that point, they are supposed to give all the results they have so far over the phone. And then if they're not turning them in within 24 hours, then the Secretary of State's office has the option to get involved and make sure that everything is finished out and they come in properly. So we already have extremely long times. I don't know why they're so long to get these things done, but it's merely a matter that they notify, and then at that point, their county can jump in and come in and help, and after 24 hours, the Secretary of State can get involved.
Okay, so you're saying the after 24 hours wouldn't be mandatory,
It's
it's
a
an
may,
option?
right,
Okay,
yes.
and then as far as the second requirement for the district judge, how is that person elected? How are they chosen? Which district judge? Is it just, because we have a lot of district judges? Is that what you said would be sort of one of the oversight individuals?
Only if that judge has already chosen to impound all the results. So if someone used the current law and they, they claimed something illegal was going on and a judge chose to impound all the election materials, then that judge is responsible for overseeing the counting after that.
So the judge only kicks in if it's impounded?
Yes.
Okay, all right, thank you for the clarification.
Sure, thank you.
Thank you, members. Any other questions? Okay, with that, we will proceed to testimony. Chair calls Veronica Worms, representing the Texas Civil Rights Project. Veronica Worms. Chair calls Kathy Hagler, representing herself. Hello, ma'am. We show you registered as Kathy Hagler, representing yourself, and you are testifying for the bill?
Yes, Mr. Chairman, that's correct.
Well, thanks for being here. Please proceed.
Thank you. Representative Swanson has given us a great resource to strongly, and I might even say very strongly, encourage presiding judges to get their precinct election records turned in without delay on election night. And I do have a lot of empathy for an election judge. If you've never been one, let's walk through it. Most of them go to their polling places on Monday to get everything set up that they can the day before, so that they don't have to come in any earlier than 6 a.m. on election day. So they've probably woken up at 5 a.m. to get there by 6, get everything to open up, all of the technology. They have to swear in their workers, finish setting up the things they couldn't do except for election day, and get everything, the zero tapes run and all that, so that they can start voting at 7 a.m. with their voters in line. So then at 7 o'clock p.m., they're not done yet. They have to undo all that. Now they got to run the election tapes. They have to close all the technology. They have to pack up all of the paperwork, do all the reports, get all the numbers. All these things that have to be done before they can take everything back to central count or a regional substation. So let's just be generous and say that when they close at night, that they're going to be finished by 7:30. We're giving them 30 minutes to close down and get all that stuff together. At this point, these people have already put in 14 and a half hours on their election day, and it's not over yet. They still have to go turn in those records. So I do have empathy for them, but this is where the craziness sets in. So we have had people who stop off at a restaurant to get something to eat because they're hungry. We have had people, don't blame them, they wanted to go to a bar before they turned in their election stuff. We have had people who said, I'm too tired, I'm going to go home and get some rest, and I'll turn it in the morning. They'll just have to wait. We've even had someone who went home first thinking they were going to bring it in just a little while, and they died while they were at home. And so they had a difficult time getting the election records from all of the things that were going on in that household. There was one lady who, her car was down and she didn't want to trust it on election day, so she rented a car for election day. It was time to leave the polling place. She put all of her stuff in her trunk. Oh, her rental's about to be up, and she's going to have to pay extra if she doesn't get her rental car in quickly. So she took it down there, got her car, and they called her a little while later and said, "Where's your stuff?" She, "Oh, I left it in the rental car." So they called the rental car place, and this was in Houston, and the car was already on its way to Dallas. It had been rented by someone else. So, different things happen. These are some of the oddballs, but there are things that happen that judges don't get their stuff in time. I think that when presenting judges go to the training this time and they find about an upgraded offense and they're saying, y'all, this is important. You got to get your stuff turned in. Come straight. Go straight. Do not stop. Bring your stuff into central count. I think they're going to perk up and listen when they hear about this bill. And then, of course, if a presiding judge is having an emergency, SOS can come in to save the day. So this is a very good bill, and I thank you, Representative Swanson, for bringing it.
Thank you, ma'am. Members, any questions? Thank you, ma'am, very
Thank you,
much.
sir.
Chair calls Dr. Laura Presley, representing True Texas Elections.
I support the bill, but I'm okay not.
You're okay? Okay. Wait, hold on. Oh, she needs to do that. Ma'am, we're going to change your registration to do not testify, if that's okay. Okay. So Chair calls Ed Johnson, representing Harris County Ballot Security and Self. Chair recognizes Catherine Kano, recognizing herself. Hello, ma'am. We show you registered as Catherine Kano, representing yourself, and you are testifying against the bill?
Yes,
Okay, thank you for being here.
thank you. So I have some concerns. I'm not strictly against the intent of this bill, but I am concerned about the way that it's phrased. The previous witness said that she thought election workers would perk up and listen about this, but what I think the effect of it is going to be chilling. We've had in Tarrant County, I've been an election worker since 2018. We have lost a lot of election workers, especially judges, because anytime changes are made that implement a criminal penalty, it's scary for them. They don't understand what the consequences are going to be, whether or not there's going to be, like, how much scrutiny they're going to be under. And this bill does not include, as far as I can tell, any provision for knowingly, which is often found in, the criminal, whenever there's a criminal penalty for election workers. So if someone doesn't know that they're required to do this, are they still going to be guilty of that criminal offense? As it was mentioned, we do have judges who, it gets late, they're tired, they want to go home, they stop at a restaurant. We've had cases where a judge decided it was just too late, they were going to go home, they took all their equipment in their car, they went home. In that case, it was already an enforcement mechanism for that because the sheriff's office got called, went to that person's house and got that equipment back. So I think that the intent is not bad, but I believe it needs some more work before it's going to be useful and not scary for people in a way that's going to discourage them from participating as workers in our election. I also think that there's part of this that's maybe missing in the fact that you do have to know that this is something you're supposed to do. But training for election judges, and specifically election judges, but also election clerks, is not mandatory. right? There is no way to make an election judge who's just signed up go to training and learn all of the rules about what they're supposed to do. Even when they do go to training, it's often very short. It focuses on specific procedures rather than all the little minutia of the law that they need to know. And experienced judges tell us all the time when we're trying to encourage them to go to training, I've been doing this for 20 years. I don't need to go to training. I know everything. But then you introduce new laws.
Thank you, ma'am. Hold on one second. Members, are there any questions of the witness? Mr. Toth?
So you would be against, even if it said the bill required some kind of a notification that they sign off on it ahead of time so they know there's a penalty? You'd be
No,
against that as well?
I would definitely be okay if there was some provision for, like, you have to know it, like, it's an offense if you do this knowingly. I would like it if there was some required acknowledgement to say that, yes, I understand that this is a requirement. I would be for that.
Members, any other questions?
I have a question, Chair.
Ms. Morales-Shaw?
Thank you, Ms. Cano, for coming again. Can you talk a little bit more about the safeguards that are already in place for a scenario where the equipment doesn't get back to central counting on time or in a timely manner?
I don't want to get too much into that because as an election worker, that's not my responsibility. So I can't talk about
Okay.
specifically what an elections office might do if that was the case. I think for that, you'd need to contact some election offices and say, what do you do in this case? But I do know that when equipment and ballots and things are not returned, those are checked in by the elections office. When they come back, we track them. We know who's supposed to be delivering them. And when they don't come back on time, there's check-ins with, like, the election judge. The election judge gets called. What's going on? Tell us what's going on. How can we help you solve this? And I do know that the sheriff's office has been involved before in retrieving those records and bringing them back so we can finish our required
Right.
duties as central count.
Okay, all right, thank you.
We have another one, if you want to let me know. Sure. Members, any other questions? Thank you, ma'am, very much. Okay. Chair calls Chuck Penny with the Texas Secretary of State's office. Sir, I show you as Chuck Penny. Am I saying your name right?
That's correct.
On behalf of the Secretary of State's office, and you are testifying on the bill. Is that correct?
Yes, sir, that's correct.
Thank you, sir. Ms. Morales-Shaw, did you have a question?
Yes, thank you for being here, Chuck. Do you have any information about what the safeguards are currently for issues that were described earlier about that delay getting the equipment back to central count?
So just to speak to the criminal provisions specifically, I know there was some question about whether there's a knowledge or intent requirement.
Okay.
The statute, as it currently reads, says only the offense applies if the judge knowingly fails to deliver the returns by the deadline. So there is a knowledge requirement there right now.
Okay.
Members, are there any other questions?
The other question
Oh, I'm
was,
sorry.
yeah, the other question was, what are the current, thank you for addressing that
Sure.
question. That was Ms. Kano's suggestion. But what are the current safeguards if there are delays, like we heard described earlier, the unusual events that might happen that create a situation where, somebody dies or they fall asleep and the equipment doesn't get back on time?
So I think the statute as it currently reads in terms of the criminal offense requires a knowledge requirement. So I think the judge would have to knowingly fail to deliver by the deadline. I think if they inadvertently or accidentally or some other event occurs that makes it to where they're unable to do so, I'm not sure that would apply. I don't want to speak too much on the criminal prosecution side, but just on the training and procedure side, I think our office would provide guidance with them on how to comply with those deadlines, and the county would provide training on how to do so as well.
Okay, so it's not completely up to the county how they manage that kind of scenario? The Secretary of State has some oversight of that or input into how that's done?
We receive calls from counties all night on election night. We have staff available all through the night. So when incidents pop up, and incidents always pop up through the election process, we always have people available to help walk them through how to deal with those scenarios.
Okay, thank you.
Thank you.
Thank you, sir. Members, any other questions?
Me. Yes.
Ms. Swanson?
Thank you. First of all, I wanted you to assure us that if an election official dies, you promise not to prosecute them.
Well, we're not prosecutors, but I can assure you the Secretaries of State's office are not.
Okay, I did want you to also reiterate to us that training is required, and if county training has passed, then they have to take the Secretary of State online training and bring a certificate to prove it.
So what the election code requires right now is it requires a county to design a training program for election workers. 32.114 of the election code says each election judge shall complete the training program and each election clerk shall complete the part of the training program relating to acceptance of voter ID. So there are requirements in the law that right now that require them to complete the training program.
Right, okay. Thank you.
Thank you.
Thank you. Members, any other questions? Thank you, sir, very much.
Thank you.
Still nobody, right? Okay. Is there anyone else that wishes to testify on, for, or against House Bill 1477? If not, the chair recognizes Ms. Swanson to close on her bill.
Thank you, Chair Shaheen and members. This legislation will increase transparency in our elections and will ensure that our election returns are returned accurately and promptly. For the sake of the perception of our elections and their integrity, I urge this committee to pass this legislation, and I close.
Thank you, Ms. Swanson. If there is no objection, the bill will be left pending. Is there objection? The chair hears none. The bill will be left pending. Chair lays out House Bill 392 and recognizes Representative Flores to explain the bill.
Thank you, Mr. Chairman Shaheen and committee members for the opportunity to lay out this bill relating to the provision of a reason for rejecting a voter registration application. Let me start off by asking you if you've ever had an official document rejected or returned because you missed a checkbox, an omitted signature or initial, mistakenly entered the current date as your birth date, or had no clue why it was rejected. It's probably happened at one point or another to all of us. Well, many Texans have experienced this same feeling of confusion and frustration when being notified that their voter registration has been rejected by their local voter registrar. HB 392 is a simple bill that will help these Texans know precisely why their application was rejected. Under Election Code 13.0373, currently, county voter registrars are required to provide notice of the reason for rejection of a voter registration application as follows. If the applicant is present upon the registrar's review of the application, then the rejection notification must be given orally immediately. If the applicant is not present, a rejection notification must be sent to the applicant in writing within 2 days. But current law does not establish that a specific reason for the rejection be included in the rejection notification. This has resulted in many applicants being provided vague, nonspecific information by some voter registrars that have made it difficult for them to know precisely where on the application the error, omission, or disqualifying information occurred. Even worse, some of these Texans receiving notices of rejection for simple errors mistakenly believe that they are ineligible to register to vote and don't try to correct the mistake or resubmit the application. HB, if they were told the precise reason, they would be more likely to submit a form correctly filled out on their next attempt and become enfranchised. HB 392 requires that the applicant be notified of which specific section or sections on the application that was either incomplete, improperly filled out, or contained information indicated the applicant is ineligible to vote. I put out some handouts. I hope you did get those. I just would like you to refer to those because currently the Secretary of State provides these templates for both the notice of incomplete information or notice of rejection. Between these two forms, using the corresponding instances of an insufficient application, every foreseeable incidence of the or reason for rejection is covered. However, these are only suggested templates. County registrars are not required to send out notice with this amount of detail, leading to a patchwork of different forms across the state. Counties can instead send notices that provide no reasoning or are much more vague and leave room for confusion for the rejection reason. Throughout Texas, county registrars should provide voter registrant applicants with a specific section and deficiency that was the cause of rejection so that they can successfully reapply without making the same mistake repeatedly. The Secretary of State's office has previously indicated that this is a change that would be very easy to implement. All they would have to do is update their current template forms to include or even categorize by voter registration application section numbers. Then counties can integrate these into their existing rejection form letters. There are no significant implications for the state or county since county registrars are already required by law to send a notice of rejection to applicants. This bill simply requires an update to that rejection form letter to be more uniform and specific and helpful to the applicant. Passage and implementation of this bill will result in reduced delays and frustration for both potential voters and county voter registration offices by increasing success rates for second attempts at registering, eliminating the need to send multiple rejection letters, and ensuring county voters remain in compliance with the law. Last session, this simple bill was unanimously reported favorably out of this committee and passed out of the House on local and consent before dying in Senate State Affairs. With your favorable consideration, Mr. Chair and members, I hope to carry it across the finish line and onto the governor's desk this time. With that, I'm available for questions, and I reserve my right to close. Thank you.
ma'am. Members, any questions for Representative Flores? Representative Raymond?
Chairman, I don't have a question, but I want to move passage of House Bill 392.
I appreciate that. Members, are there any other
Is that-
members?
is that a
I-
yes?
Any other questions?
I have a comment.
Ms. Morales-Shaw.
Chairman. Thank you, Mr. Chairman.
I tried.
Thank you, Rep. Flores, for your bill. It sounds like a good common sense bill. On the form, I'm looking at the form. Did you say that this was just suggested verbiage for a form amendment? Or did- Uh-huh.
Sorry, the Secretary of State actually has those forms, and they
Okay.
can provide them to the counties, and they can incorporate them. They can use them as is. They can incorporate them into their notices of rejection or incomplete information. So they're there for their use, and they can be
Okay.
utilized for that.
I'm curious, does the form have a contact phone number or email so that the recipient knows where they can get other information? And also, what if it's none of these A through E? Is there an other column? And yeah, oftentimes it's helpful for people trying to register to vote to have a authority to go to, whether it's a phone number or an email, something that would help them rectify their voter registration.
Well, I could imagine that there'd be other reasons that they could add if it was something that they feel was missing, and I'm sure that there would be a cover letter from the county registrar with their information about where to contact if they had any further questions, I would imagine. This is just a form or a template that could be sent along with their letter or incorporated into their letter, but it would be an existing form that would go out from the county registrars with information about their contact information.
Okay, thank you.
Members, any other questions?
There might be a resource witness or somebody that's signed up, I'm not sure, but I'm happy to come back and close if there
Okay,
are.
great. We'll proceed to testimony. Chair calls Ed Johnson with the Harris County Ballot Security and self. All right, okay. Is there anyone else that wishes to testify on, for, or against House Bill 392? If not, the chair recognizes Representative Flores to close on her bill.
Thank you again, Mr. Chairman and members. Hopefully, this bill that is very simple and it will help voters to correct any mistakes they've made on their mail-in voter registration, and they will be able to correct their future applications and be eligible to vote. So I ask for your support and your vote. Thank you so much.
Thank you, Representative.
Ms. Raymond, I appreciate your vote of confidence in me.
If there's no objection, the bill will be left pending. Is there objection? The chair hears none. The bill is left pending. Chair lays out House Bill 1090 and recognizes Representative Paul to explain the bill.
Thank you, Mr. Chairman, members. Good to be before you here. simple little cleanup bill. In the fall of 2023, a volunteer deputy registrar in B County was charged with an offense for falsifying government documents by submitting false voter registration forms. The individual has registered real voters by moving them into addresses into his relative's JP precinct for their race. There's a loophole in the law where an individual can be charged with an offensive crime committed by discharging their voter registrar duties and still be eligible for future appointment or service as your VDR. So this bill tries to clarify that situation by saying that if you are charged with a crime, that you cannot be a deputy voter registrar, and unless you're not convicted of any crime, then you can always come back. We're currently working on committee substitute that will apply to those currently. So the way the bill's drafted right now, it just says, all right, if you've been charged with a crime, you can't get reappointed. But this, we're going to put a city substitute in that says, all right, you can be removed from your current charge while you're charged, and then also you can't be reappointed. Unless you're, obviously if you go through the system and you're not found guilty of any crime, then you could continue to do it. So with that, I'd be glad to answer any questions.
Thank you, Representative. Members, are there any questions for Representative Paul?
Just one.
Vice Chair Busey?
Thank you, Mr. Chairman. Representative Paul, you just said it, I believe. So they're charged, I understand, want to suspend them and then look into that. Are we sure they get to be reinstated if they're found to be innocent?
Well, they could be reappointed when the appointment process comes back up.
Okay,
Yeah,
and
so
this wouldn't restrict that?
Yeah, well, just, then they wouldn't have low law would stop them from doing it.
No, I'm with you. I just worried because it says charged, and so just making sure.
Yeah,
Right.
yeah, so if you're charged, we're saying, all right, you got, and let me be clear, sorry, Vice Chairman, good point. If you're charged with a crime dealing with your duties as a voter registrar, right? So
I
it's gotta
agree.
be duties discharging are not if I got a DDI or something. It's a charge with duties of doing my actual job as a voter registrar.
And-
you would be removed, and then you couldn't be reappointed until after you're cleared of all charges.
And I fully intend to support this. I just want to make sure if they are found that the charge was false, that they can get back into the role.
Absolutely.
Thanks, sir.
Members, any other questions? Thank you,
All
Mr.
right,
Paul.
well,
We'll proceed to
I'll
testimony.
reserve the right to close. Thank
Yes,
you, Mr.
sir, we
Chairman.
recognize that right. Chair calls Kathy Hagler, representing herself. Hello, ma'am. We show you registered as Kathy Hagler, representing yourself, and you are for the bill.
That's correct, Mr. Chairman.
Thank you for being here. Please proceed.
Thank you. So I will not reiterate the story he just told, but I was also involved in that. I heard about that in September of 2023, what happened in B County. And to be a little bit more specific about the citations, the voter registrar would normally be able to reject an application for reappointment under Election Code 13.032, but that didn't cover it. So if you go to Election Code 13.031 about appointments, this man was still eligible to be appointed because even if he had already been convicted, he was being charged as a misdemeanor, and 13.031D says they have to not have been finally convicted of a felony. So that's why this man was still eligible for appointment. Another source that we went to was Penal Code 32.51, which is fraudulent use or possession of identifying information. And normally that would have made someone ineligible, but it only applies if it's proven that the false voter registration forms were without the signer's consent, and they were not able to get that. So that's why he was able to be reappointed. Even with all these things in the law, you would think that he shouldn't have been able to be reappointed. So when I went to the Secretary of State's website to the VDR page, here's the very first sentence that it says. Volunteer deputy registrars are entrusted with the responsibility of officially registering voters in the state of Texas. And members, we really only want people who we trust to be entrusted with the privilege of being a volunteer deputy registrar. So I ask you to vote for House Bill 1090 in committee and again on the House floor. That's all.
Thank you, ma'am. Members, any questions? Thank you very much, ma'am. The chair calls Taylor Trevino with the Texas Civil Rights Project. Hello, ma'am. We show you registered as Taylor Trevino with the Texas Civil Rights Project, and you are testifying against the bill. Is that correct?
Yes, that's correct.
Okay, thank you. Please proceed.
Thanks. Yes, my name is Taylor Trevino, here representing Texas Civil Rights Project to register our opposition to HB 1090. I will also say I'm a VDR. I've been one for 5 years. One of my favorite volunteer activities to do, and definitely a responsibility that I take very seriously. This bill would prevent a person from being a volunteer deputy registrar if they are being charged with a felony or a crime allegedly conducted in the course of their duties as a VDR. Texas already has one of the most restrictive voter registration systems in the country, since we do not have online voter registration, as 42 other states in our country do. VDRs are essential to make sure that voters in remote areas or who don't have the means to visit DPS or their voter registrar can register to vote with the help of someone in their community. They also allow voters to register when they see a voter registration drive in their area, helping Texans participate in our democracy. The fact that a person could be prevented from serving their community for a mere charge, which requires no actual proof in order to level, would potentially disenfranchise voters who rely on VDRs to help them navigate the registration process, especially when the vast majority of alleged election-related prosecutions turn out to hold no water. Depriving voters of one of the only methods they have to register to vote in Texas because of a charge that could be baseless is not the best way to serve Texans. We ask that you not vote this bill out of committee. Thank you.
Thank you, ma'am. Hold on just one sec. We just want to see if anybody has any questions. Members, any questions? Thank you so much for being here.
Thank you.
Chair calls Ed Johnson with the Harris County Ballot Security and Self. Is there anyone else that wishes to testify on, for, or against House Bill 1090? If not, the chair recognizes Representative Paul to close on his bill.
Thank you, Mr. Chairman. I wanted to comment on some of the testimony. You can't be charged without having a probable cause and investigation, so nobody's going to be frivolously charged. And if it's a felony, actually, you're going to have to be charged by your district attorney and be indicted by grand juries for a felony. So that's not going to be any kind of frivolous thing. And if the other ones, you're going to have probable cause and investigation. So that shouldn't be the case happening. And again, it's only for charges that you do while you're doing your active duties as a deputy voter registrar. And it is a privilege. It's not right. And we want to make sure that people who are doing it are somebody who can trust the integrity of our elections. With that, I close.
Thank you, Mr. Paul. Is there any questions from the members? If there's no objection, the bill will be left pending. Is there objection? The chair hears none. The bill is left pending. Chair lays out House Bill 1091 and recognizes Representative Paul to explain the bill.
Thank you, Chairman Shaheen, Vice Chairman Busey. Appreciate your chance to listen to this bill. When election results take a long time to report, voters start to worry about the integrity of the election, the process, and everything that goes along with it. House Bill 1091 improves how election results are handled by making these key changes. The bill pushes back when you have to postmark your ballot in the mail to a Friday before a Tuesday election, and pushes back when mail and the ballots have to be received to 5 p.m. the day before Election Day. Timelines to begin counting ballots differ based on the county size and the process that you're going to be doing your counting. But all those has to be done and completed by Election Day so that results are posted by 7 p.m. So basically, what we're saying is election by mail is going to be aligned with election in person. Both of them are voting early by mail or voting early by person. They both have to be finished by Friday. They both have to have their reports. We're not changing the voting in person. I'm just trying to bring a parallel. They both have results done at 7 o'clock. So the only thing that's out, the three things that that election folks have to do is early voting, ballot by mail, and Election Day voting. So two of those three are going to be reported at 7 o'clock. That takes care of all voters' empathy about or worry about the campaign and the election, because this voter by mail is going to be counted and it's done, and we can take care of it. Also, by moving it back to Friday, we're also going to give you an extra day that those ballots can come in. Current way that they have to come in, by 5 p.m. on Wednesday to be counted. Although, no matter where you announce the election, you could still count it to Tuesday at 5. This will give you an extra day that the mail could actually get that in and process so we can count it. So hopefully we'll have more ballot by mails counted and eligible to be counted. So I think we got some good stuff on both sides of there to get the reporting in, as well as giving some extra time for the mail to get in and count those ballots. So I think it's a great piece of legislation, and would love to answer any questions y'all have about it.
Thank you, Representative Paul. Vice Chair Busey?
Thank you, Mr. Chairman. Representative Paul, you said pushes back, but how I'm reading it, you're pushing the deadlines up. Right now, the application you could do up until 11 days before the election. Now you're making it 15, so 4 less days to apply for your ballot. And then you said an extra day to receive, but under current law, it is after Election Day, the next day, 5 p.m. after Election Day. You're making it the day before.
Yeah. So
you said
but
in your
since
layout
you had to
pushing it back, but
postmark
you're pushing it up.
Yeah, so by postmarking it on Friday, that gives me Saturday and Monday to get those for the post office to actually do the work.
Well, but
if you actually voted on Election Day, which most people don't by mail, but if you did vote on Election Day and you put it in the mail at 5 p.m. on a Tuesday, how much do you think it's really going to get counted by 5 p.m. on Wednesday?
No, I
Do you
just
think
want to,
the
but I'm
mail
not sure
service is that
shortening
great?
the time frame is going to help us with having to throw out less good ballots. I mean, one of the leading causes that a good ballot is thrown out in Texas is because they're received after the deadline, and now we're shortening that deadline by a day, are we not?
I don't know how you grasp that we're shortening the deadline when you have to put it in the mail by Friday. You get Saturday mail is delivered still, so you get Saturday the post office working, is Monday you're getting the post office working. You're actually doubling the time that the post office has to collect those ballots.
No, you're adding a new arbitrary deadline for postmark, and you're giving 1 less day for the ballot to be received. So we already throw out, the leading cause of good Texas citizen ballots being thrown out is because they were received late, and now your bill is shortening that by a day.
Because, Chairman Busey, because it's late, if you mailed it on Tuesday, you're not getting it by Wednesday by 5. That's what makes it late.
Well, we already have a deadline, which is the next day after
If you mailed it
Election
on
Day.
Friday, that gives you the post office 2 days to get it into the process.
What
So
part
you're
of-
actually going to be able to, you're increasing more time for the mailman to actually get that post office there.
You're making shorter time for a ballot to be cast. And let me ask you this. With the way you're doing this, what is the problem that is happening right now with the system? I mean, it shows up the next day, they go and check. It had to be postmarked before Election Day deadline. So I'm just trying to understand, so we know they cast it before the election closed, and now we're giving them 1 less day to receive a good ballot that is now going to be thrown out. And this is already the leading cause of ballots being thrown out.
There's no less days to receive. The date that the county sends a ballot out is the same day it always has been.
No, receive
Right.
back to the county. There is a less day for your vote to be cast under this bill. And I have other issues with the bill, but that is substantially at the heart of it.
Yeah,
because
that's-
we're saying 1 less day for a ballot to come in and be received. When we've seen in spikes with the mail issues, sometimes it's staggering, but we know they cast the vote because it has to be postmarked, and now we're giving them 1 less day to receive it. And so we're going to throw out
You get an
Texans'
extra day
votes
to
with this
receive
ballot.
it. I don't know. You keep saying you're getting to
Well,
receive
okay,
it.
page 2.
The guy has to have it. He can't vote on Tuesday, the election day, if it was the 5th. He'd have to be done by November 1st. Yes.
Page 2, lines 7 and 8, not later than 5 p.m. on the day before Election Day, which right now it's after. I mean, you see that they strike out after there in the law.
Yes.
So we're giving 1 less day under this bill for a vote to be cast, even though it was sent before Election Day ended. And we already know that from the postmark day. Has there been a problem with us not having election results because of ballot by mail anywhere in the state that we need to go move this up? Because I'm not aware of any.
Yeah, we are.
There's been
Obviously,
delays
there's
because of
many a
ballot by
case-
mail?
There's many a case that had a problem with ballot by mail.
For delays
then
in
the
election results?
Yes, and the
Where?
results are it happens all over the nation. And what the results are, what we're saying is that you have to have these results done by 7 o'clock on Tuesday. The benefit for everybody in the state to have that result by 7 o'clock is what we're going to be able to have that advantage, as well as the fact that you get the benefit of having the post office an extra day to actually mail the ballot. And the fact that 90% of the mail, making up numbers here, I'm sure that people are voting before Election Day. So you're really not going to interfere with anybody's voting.
If you want to make sure that we have the post office have more time, I'm happy to work with you on that
All right,
kind of
well,
bill.
that's
But
what this bill
is a day
does.
less of receiving Texans' ballots. And I think that's incredibly
I think we're
problematic.
trying to
We're
get
going to throw
more.
out Texas
I think
goods ballots.
we will actually get more ballots in with this process.
Well, I just respectfully disagree. I think this is going to be very problematic to throwing out good Texas
I
ballots.
appreciate that,
Thank you,
sir.
sir.
Representative Raymond.
Who's on first and what's on second?
The bill's on first.
I'm sorry. That's all I could think of listening to these two guys.
Any other,
We're two people that have done elections for a very long time.
any other questions? All right, I'm losing control here. Thank you, Mr. Paul.
All right, reserve the right to close. Thank
got
you,
it.
Mr. Chairman.
Yeah, we'll proceed to testimony. Oh, gosh. All right, hold on here. The chair calls Marliza Marin, representing Common Cause, Texas. Ma'am, we show you registered as Marliza Marin, representing Common Cause, Texas, and you are testifying against the bill?
Correct.
Okay, thank you, ma'am. Thanks for being here. Please proceed.
Thank you. Hello, Chair Shaheen, Vice Chair Busey, and committee members. My name is Marlisa Marin, and I am here to testify against HB 1091. In 2024, approximately 342,000 Texans voted by mail. This bill would make an already complicated vote-by-mail process even more difficult, creating unnecessary barriers for voters who rely on it. Most people don't start thinking about an election until right before Election Day. By moving the application deadline from the 11th day to the 15th day before the election, this bill would cause more voters to miss the deadline, ultimately reducing access to the ballot. Texans who travel for work may not even know where they need their ballot sent 2 full weeks in advance. Additionally, requiring that mail ballots be received by 5 p.m. is simply not feasible. Counting ballots takes time, but speed should not come at the cost of disenfranchising voters. What matters most is ensuring that every eligible voter who relies on vote by mail, like elderly Texans, voters with disability, pregnant women close to giving birth, and military members serving our country, has their votes counted. Their voices matter, and this bill would make it harder for them to be heard. Please do not pass HB 1091. Thank you for your time.
Thank you, ma'am. Members, any questions? Thank you, ma'am, for being here.
Thank you.
Chair calls Kathy Hagler, representing herself. Hello, ma'am. We show you registered as Kathy Hagler. You're representing yourself, and you are testifying for the bill.
Yes, Mr. Chairman, that's correct.
Thank you for being here. Please proceed.
Thank you, Mr. Chairman and members. We have all been there on election night. It's 7 p.m., it's 7:30, it's 8 p.m., and where are the stinking results? Everybody's looking for the results. Well, results are coming from 3 different places. They're coming from early voting by mail, early voting in person, and Election Day results. As Representative Paul already mentioned, early voting in person already ends on Friday night, so this is only saying that early voting by mail would also end on Friday night. The early voting by mail and early voting in person numbers are combined when you see those unofficial reports, and they just show us early voting together. And then there's the Election Day, which obviously takes longer because they are doing all those processes we talked about in another bill I've already testified on. So if it's done well and done right, both types of early voting should be processed and tabulated and in the machines where at 7:01 p.m. they hit the report button, the report spits out. Of course, we do everything to the mothership first. It goes to SOS, and then it should be on the county website by 7:02 p.m. All of the early voting results, not just partial, because you've had the time to process them. So let's go to the early voting in person, ending on Friday night. They have between Friday night and Monday for all the paperwork coming in from those judges, the equipment's being packed up, the reports are being reviewed, the ballot memory cards are sitting there. Everything's waiting to be processed so that right at 7:00 p.m., boom, you already have your early voting in person numbers. We're trying to make that happen for ballot by mail. But as it stands right now, the law currently allows a voter, they only have to postmark their ballot by Election Day Tuesday, but as long as it's, this is a general election, of course, but as long as it's received by 5 p.m. on Wednesday, it's considered timely and may be accepted if there's no other defects, like a missing signature or a missing PII number. So the only ballots by mail that are reported on election nights are all the ballots that are received by the Postal Service or common carrier on election day, or a completed marked ballot by mail that is hand-delivered by the voter to the main elections office on election day. Now remember, they can walk their voted ballot by mail into the main elections office until 7 p.m. And that ballot has to be in tonight's results for the election night. Now, your voter early voting clerk is going to have to register that in Teams. It's going to have to go through the ballot board, possibly a signature verification committee as well, and there's a lot more to be processed. I guess I need to stop. I have a lot more information, but I will stop.
Thank you, ma'am, very much for respecting the time. Members, any questions? Ms. Isaac?
Yeah, well, I would like for you to continue. I'm sorry. I'm interested in this process, so will you continue, please?
Yes, ma'am. Thank you. For the ballot by mails that don't even come in until Wednesday, those ballots are not going to be counted until they're added in with the late arriving ballots and the provisional ballots when the late ballot board meets in another 9 to 14 days. So a lot of people don't pay attention to that late report. They pay attention to the unofficial results that come in on election night at 7 o'clock, or should be coming in right around 7 o'clock for the early voting. And it's not really fair to a ballot by mail voter who brought or sent their ballot in on election day. It was received by 5 p.m., but their ballot isn't counted until like a week and a half later. So we want everybody who votes before the election for their vote to be counted and included in the unofficial returns that happen on election night. So since Representative Paul's 1091 moves the deadline to receive a ballot to 5 p.m. before the election, he offsets that by adding days to the deadline at the beginning of the process for receiving an application so that voters are not getting a shorter period to vote by mail. We're just moving it back a couple days. So if everything's done right and done well, we have a cutoff to receive the ballots at 5 p.m. on a Monday if it's a Tuesday election. And now the Signature Verification Committee and Ballot Board have a known quantity of how many ballot by mails there are, and they can finish their work on Monday night. They have all day Tuesday to work on it, and by 7 o'clock, all those things should have already gone through the machines, and they're going to hit that button, that report button, and they're going to have results at 7:01. And I think y'all want that, and I'm telling you, your constituents do too. So this is that bill that if we pass this bill and the governor signs it, and you go out to your constituents and you say, this is a bill that we passed, you're going to love it. We're going to start getting results earlier on election night. You're going to get a standing ovation. That's all I can say about this. It's a very good bill.
Okay, thank you, ma'am, very much. Members, any other questions? Thank you, ma'am, very much for being here.
Yes, sir. Thank you.
The chair calls Mary Ibarra with ACLU of Texas. Welcome, ma'am. We show you registered as Mary Ibarra.
Ibarra, yes.
Ibarra, thank you. And you are with the ACLU of Texas, and you are testifying against the bill?
Yes, I am.
Welcome, and thanks for being here, and you can begin.
Awesome. Good afternoon, representatives. My name is Mary Ibarra. I'm a voting rights strategist representing ACLU of Texas, and I'm testifying in opposition to HB 1091. Voting by mail is meant to provide greater accessibility for voters, and this bill would severely limit the period in which someone can vote by mail, and in do so add a greater burden to voters who need it the most. It would move up the deadline to request a ballot by mail by 4 days and require a completed ballot to arrive before 5 p.m. the day before Election Day. Voting by mail is extremely restricted in Texas. There's already a limited amount of people who have access to this program, and there's a very tight time period to request, receive, and mail out their ballot. Any new legislation that limits access to voting will leave voters behind when in practice, and ballots will come in after 5 p.m. on Monday, and those received between then and the end of Election Day will not be counted. For this reason, I urge you all to vote against this bill.
Thank you, ma'am, very much. Members, any questions? Thank you, ma'am, very much. Chair calls Taylor Trevino with Texas Civil Rights Project. Hello, I show you registered as Taylor Trevino, representing the Texas Civil Rights Project, and you are testifying against the bill?
Correct.
Thank you,
Yes.
ma'am. Please proceed.
All right. Chair Shaheen, Vice Chair Busey, and members of the House Elections Committee. My name is Taylor Trevino, and I'm here representing TCRP against HB 1090. While we have several concerns with this bill, my focus today will be on the mail-in ballot and the application for mail-in ballot return requirements. HB 1090, as has already been stated, would require voters to return their application to vote by mail by the 15th day before early voting starts instead of the 11th day. Moving the deadline up by 4 days for no adequately explored reason will cut the amount of time that voters have to decide whether they need to vote a mail-in ballot and apply for one by almost a third. People decide to vote by mail for many reasons, whether they'll be out of the country because of work or school obligations, if they experience a disability that makes voting in person untenable, or whether they have just turned 65 and wish to receive their ballots by mail going forward. Affording people enough time to make that decision is crucial to making sure that every eligible Texan has the ability and opportunity to vote. An even bigger problem, however, is moving up the date that the mail-in ballot must be received by the county and the date that the mail-in ballot must be postmarked. HB 1091 requires a mail-in ballot to be received by 5 p.m. the day before Election Day and be postmarked by the 4th day before Election Day. Respectfully, this provision makes no sense. A voter should be able to mail their ballot on Election Day, and as long as it's received before 5 p.m. on the day after Election Day, the ballot should be counted. The idea that you can't mail your ballot to the county on the same day that you can submit the ballot to the county in person doesn't make sense. This bill would require a voter to mail their ballot in 4 days before Election Day to have it counted, effectively reducing the early voting period just for mail-in voters. Arbitrarily reducing the amount of time that voters have to return their ballots to have them count will disenfranchise voters who most need the system's protections to have their votes counted, namely voters with disabilities, voters over 65 years old, and voters who will not have the ability to vote in person because they will be out of the county. We ask that you not vote this bill that will disenfranchise voters through gaming the timeline they have to submit a ballot. Thank you.
Thank you, ma'am, very much. Mr. Raymond?
Thank you, Chairman. And you may not know this, and answers to a couple of questions. We may have to resource Secretary of State, but let me ask, since you're testifying, do you know, like what percentage in Texas of, even if we talk about general election, if you want, whatever is easiest, what percentage of mail-in ballots, or what percentage of ballots are mail-in?
I don't have that information currently.
Do
I'm
you
happy
know?
to follow up or see if someone else.
Yeah, they may. Maybe you'll know, and if you don't, Secretary of State, we'll bring them up and see if they know. If they don't, they can get back with us. I'm just curious, because I'd like to see if it's going up. Like, is the percentage of the mail, are the percentages going up of ballots that are mail-in? Second of all, would you have some idea what percentage of the mail-ins are, because of disability or because of military service or seniors, right?
That's also not information I have off the top of my head, but we'll just also state that, as I think everyone here is familiar with, the mail-in process is already extremely limited. So
Say that again?
The mail-in ballot process is already extremely limited, in terms of who's able to access it in Texas. So I don't have specifics on what the ratio is.
Wait a minute, what do you mean it's extremely limited in terms of access?
In terms of who is eligible, who qualifies to vote by mail in the first place. So just stating that it's already a, a restricted process.
So
I don't see any
military,
need.
disabled, over 65, out of town, is that right?
Yes,
College, right?
yes.
So I'm trying to remember, do you remember what we've cut back on? Like, who used to be eligible and is not?
I don't have that information off the top of my head. I'm happy to follow up on that.
Do you know if we, and I'm sorry I don't know, Chairman, and maybe the Vice Chairman or somebody else, and if they do, y'all can jump in. Just as a reminder, like, have we scaled back on who qualifies? So maybe some other witness can address that. And I guess one of the things is, how long have we, again, if you don't know, it's okay, but you might. Like, when did we move it to, they've got to be postmarked by Friday, is that right? Before Tuesday, and received by Wednesday, or postmarked by when is it?
Yep, postmarked by 5 p.m. Election Day. Is that correct, Vice Chair?
Postmarked by E-Day? And received the next
Received
day?
by the next day. Yes.
And how long have we had it like that?
Don't have that information off the top of my head. But happy to
Okay.
follow up on that.
Well, the Secretary of State can get us that. I'm just trying to see kind of where, how long we've been doing that. I mean, I'm one of those guys. I want people to vote. I want them to have the ability to vote. But I know how many people don't vote. Okay, a lot. And I kind of, I mean, I feel like I partly understand where Representative going with this, is that, if you've got to walk in, if you're going to do early vote by walk-in, you got to go do it by Friday usually, right? Before the election.
Yes, for
So
general election.
they've received your ballot. If you're early voting, they've received it by the Friday before the election, right? But with the mail-in, we're kind of changing the rules and saying, well, if you're going to mail it in, well, we're going to give you extra time. Right?
Yeah, and just want to state too that a lot of people use mail-in ballots because they don't physically have another option. Of course, if they'll be out of the county, if they have a disability, which I think is something that we should be particularly sensitive to. And as I stated, we're reducing that timeline just for mail-in voters.
Well, what
but not
gets back
for-
to my original question, like about how many people that are using, mail-in are, what percentage are disabled? And are the numbers of the people who are voting mail-in, is that going up? Is it going down? Is it stagnant? Is it, you know what I'm saying?
Yeah.
I'm trying to get a sense of to what extent.
Yeah.
To what extent it.
I think it would be fair to say a good chunk of people using mail-in ballots are likely disabled or over the age of 65. But again, happy to follow up on specifics. And just to hit on a previous point earlier, even if Texas's laws have been a certain way for a certain amount of time, that doesn't mean that's the only way that they can be. And we look at other states that have no excuse mail-in voting or universal mail-in ballots. So just because we have our laws one way doesn't mean they have to just be like that.
Say that again?
Just because our laws are a certain way and have been that way for a while does not mean that that's the only. Doesn't mean they can't be improved or that we can't, expand access to help more people be able to access the ballot.
No, I know, but I mean, we have election day. There's like, candidly, for me, I've thought for a while that, with the exception of the military, active duty military, ballots, sort of giving them ballots an extra time to get in, because active duty military, it's just tougher. I mean, and I get it, and I feel like, I support that. Beyond that, I've just kind of wondered why we do that. Why you can get a ballot after the election and it still counts. Now you can blame it on the Postal Service, I suppose, and say, well, the Postal Service, but that's probably not fair, because it makes it sound as though the Postal Service is deliberately, holding them back or taking longer. You know what I mean? And so I'm just trying to figure out how we move forward. But I think it's important to know where we are, and I'm going to ask the Secretary of State to find out for us what percentage of the mail-in ballots are from disabled folks, right? What percentage are from over 65? What percentage are from, military? And is it going up? Is it going down? Is it just basically been the same for a while? I think that would be important to know. Thank you very much.
Thank you.
Members, any other questions? Thank you so much, ma'am.
Thanks.
Chair calls Ed Johnson with the Harris County ballot secure, with Harris County ballot secure in self. Hello, sir. That's all right. We show you registered as Ed Johnson with Harris County ballot secure and yourself, and you are
It should be ballot security. I'm sorry, I mistyped that.
Harris County Ballot Security is the name of your organization?
Yes.
Hold on one sec.
But it can be secure for this hearing. That's fine.
Okay. So we've updated, it's
Thank you.
now stated that it's Harris County Ballot Security. And you are testifying for the bill, is that correct?
That is correct.
All right, thanks for the clarification. You may begin, sir.
Okay, so little history. Back when I was working in the election department in Harris County, one of the problems we were having was we would receive the next day after the election, we would receive fairly large quantities of ballots. And we were working with the post office, and they were telling us that they just didn't have time to get those processed and, postmarked and pushed out the door. So actually, I helped push the legislation to make it one extra day to give the post office some more time. It didn't help the post office. They still, even the following day after that, we were getting ballots that were coming in late that they definitely had for a time. And it was funny because they were all from the same zip codes, usually. So I will tell you that giving the extra day did not really help the post office in getting these ballots delivered timely here. So I think this bill would actually help the voters a whole lot more because you're putting the deadline, the 5 o'clock before the election. And the voter always wants to know, did my ballot get here and get counted? But by putting the deadline at that time, the election department, if a voter calls in and said, did you receive my ballot? They can answer them right then and there, yes, we have your ballot. If they didn't receive it by that time, that voter still has a chance that they could go in on election day and cast their vote, and gives them that opportunity. Right now, under our system, they call the election department, well, we don't know, we haven't got it from the post office yet, and it ends up being late, and then their vote by mail ballot is not counted. So I think this is a whole lot secure for the voter to be able to know, did you get my ballot or not? And if you didn't, it gives me an opportunity to fix the situation and go vote on election day.
Thank you, sir. Members, any questions? And Mr. Johnson, we show you actually registered twice. The second time you're shown as you're not going to testify, so we're going to delete that and show you as
I
testifying.
tried to delete it, but it wouldn't let me do
That's
it.
all right. We'll take care of it for you.
All right. Thank you very much.
Thank you, sir, very much. The chair calls Catherine Cano, representing herself. Hello, ma'am. I show you as registered as Catherine Cano. You are representing yourself, and you are testifying against the bill?
That is correct.
Okay, thanks for being here. You may proceed.
Thank you. So I'm not going to get too much into the issue of timelines because I believe that Co-Chair Busey has already addressed that quite thoroughly, as well as some of our other witnesses. I will say that I think some of the statements that were made regarding when ballots come in and the presumption or the idea that this is going to make reporting faster is not true. We are already required to post all of the results that we have at 7 p.m. That includes all of the mail ballots that we physically have in our custody. Everything has to be processed on election day. If we do not process those ballots, we're going to get a court order from a judge saying you need to keep working. And in 2020, that is exactly what happened in Tarrant County. So anything that we physically have in our custody is going to be posted on election night. Those results are going to be in. We are still going to be waiting for overseas ballots, the FPCA ballots. Those are our military voters. They have up until, I believe it's 4 days after Election Day for those ballots to come in and be processed by the ballot board. So there are going to be, even with this bill, outstanding ballots that will not be part of the results that are posted on election night. I think it is, there was an interesting point raised that our mail ballots and our in-person early voting ballots, the totals are not discrete. They're all cumulative. And people may be interested, like, what if we just separated those out and said, report your mail ballots as one thing and report your in-person ballots as one thing, and then we know we're not getting any more in person, so we're just waiting on mail. But again, a lot of people have said a lot of things of that. I'm not a big fan of this bill because it includes so many different things that are not necessarily related. There's a lot of reporting requirements, which I think are good, but I would be more inclined to support them if they were individual bills, because I think overall this bill is not good. And I'm also concerned about the section that says, has to do with central counting, where it says that the central counting station may not accumulate the results of early voting ballots, but in the election code, there is no reference to the term accumulate or accumulation except in 211.007, which is the preservation of recount papers, and it has to do with literally just a pile of paperwork. This is tabulation.
Thank you, ma'am.
Additionally, I have some information on stats if you would like to contact me separately.
Thank you, ma'am. Members, any questions? Thank you, ma'am, for being here. Chair calls Susan Valiant, representing herself. Hello, ma'am. I show you registered as Susan Valiant. You're representing yourself, and you are testifying for the bill?
Yes, I am.
Great. Thanks for being here, and you may proceed.
Thank you, Chairman Shaheen and members. I wanted to talk about this. I'm in favor of this bill, especially with the timeline that it is, but I would like to make an amendment to the bill or a substitution to the bill in order to add the CAS system, which is the coding and accuracy support system that the UPS provides in order to make sure that the letter or the mail-in ballots, because it deals with bulk mail-ins, it's kind of like Amazon. They make sure it gets to the exact address that it should get to. And I think that would help facilitate, anyway, the mail-in ballots as far as getting them in return. And it would also save the county money as far as the returns and then having confirmations go out to confirm that that address is actually their address. And so that's all my testimony.
Thank you, ma'am. Members, any questions? Thank you, ma'am, for being here.
Thank you.
The chair calls Chuck Penny. Sir, I show you as registered as Chuck Penny. You are representing the Secretary of State's office, and you are testifying on the bill.
Yes, sir, that's
Thanks
correct.
for being here. Vice Chair Busey?
Thank you, Mr. Chairman. A bunch of things, but with what Representative Raymond was talking about, I believe it was a 2017 bill that we also had a witness at Johnson say he helped on by Bedencourt and Schofield that moved it to the day after. Is that your understanding?
I was asking my team about that while some of the other witnesses were testifying. HB 1151 is what we found that set the postmark deadline.
The vote on that was 143-0, and Representative Raymond, you supported it because it was a good idea then, and I believe it's a good idea now to allow for the ballots to come in the next day.
Yeah,
And
so what was it before that?
I don't know that. I was trying to get an answer to your question. I don't know.
Yeah, I was trying to, but, so what was it before that?
Hold on.
Okay,
Vice Chair
I'll
Busey-
ask him.
Well,
So-
hold on. Vice Chair Busey has the floor right now.
So I think one of the things being lost here, and you can walk us through it, we keep talking about ballots being cast or ballot by mail gets more time. That's not correct under current law because you have to cast your ballot and postmark it and send it. Is that not correct by Election Day?
That's correct. So I think there's delivery timelines and then counting timelines that are a little bit different. So with delivery timelines, there's basically two categories of ballots. For domestic voters, they have to postmark the ballot by 7 p.m. on Election Day, and the ballot has to be delivered to the elections office by 5 p.m. on the day after Election Day.
So a little more clarification of that,
Sure.
because I don't think this bill addresses the military. So staying specific to people that are here voting by mail, you just said it has to be postmarked by 7 p.m. on Election Day. So that's no extra time to cast that ballot. Is that correct?
7 p.m. on Election Day, that's correct.
Now, what if they're in line and they doesn't get postmarked by 7? That wouldn't count. It wouldn't meet the standard, would it not?
Yeah.
But if I'm in line to vote in person by 7 and I'm in a long line and don't vote till 11, I actually have more time. Is that correct, as long as I was in line first?
That's correct.
So we're not talking about extra time if you cast a ballot by mail. What we're talking about is for the post office to be able to receive that the very next day, but it still had to be postmarked by 7 p.m. on Election Day, correct?
That's correct.
So no extra time there. Now, turning to this bill, if we look, and there's multiple things to talk about, but to really just hammer down, because the layout said pushing back, but my reading of this is we are pushing up. On page 2, lines 7 and 8, currently you can receive the ballots in the mail the next day, after Election Day, as long as it was postmarked by 7 p.m. on Election Day. Is that correct?
That's correct.
And under this bill, if it was to become law, you have to receive them by when now?
The bill says not later than 5 p.m. on the day before Election Day.
On the day before Election Day. So now you have, if you're voting by mail, you have less time than someone else to cast a vote if this became law. Is that correct?
The delivery deadline is earlier, that's correct.
Is the time to send it in not earlier also?
Yes, that's correct.
Okay, so you have less time if this bill to cast a ballot by mail. Is that correct?
Both the postmark deadline and the delivery deadline are earlier, that's correct.
So less time to cast a ballot. And then, do we have ballots that are thrown out in this state because they were received after the deadline of the next day, even if they were postmarked and cast by a Texas citizen? Does that happen in this state?
If a ballot is received after the deadline for delivery, it would not be able to be counted.
Even if it was postmarked by 7 p.m. on Election Day, and even if it was cast otherwise by someone that was eligible to vote?
That's correct. It has to be postmarked by the deadline and delivered by the
Do you know the stats of how many ballots are thrown out, the percentage for that?
Don't know the stats, but we'd be happy to get you that information.
I'm struggling to find the number too, but at times there's been thousands of ballots thrown out. In primaries, it's of course lower, but in general. And so we're talking about ballots by Texas citizens, postmarked by Election Day at 7 p.m., being thrown out already under current law. And this would take us from a day after Election Day, not to Election Day, but a day before. So we're cutting out a couple of days in the time that it can be received. Is that correct? If this became law?
I don't know the numbers, but the timelines are shorter.
Timeline's shorter, and therefore likely to lead to more Texas citizens casting a valid ballot in time, but having it thrown out and their ballot not counted. Thank you, sir.
Mr. Raymond?
Thank you, Chairman. So, getting back to what Vice Chair Busey was asking, what was it before the 2017 or 2018 or whatever?
I don't know. I know the bill that changed the postmark deadline. We could find out more information on what the bill used to read.
Yeah, I just don't remember what it was. Chairman, were you here already by 17? You weren't.
I came in 19.
What about you, Chairman? Were you here?
Mm-hmm.
Do you remember? Dude, I don't. I was hoping somebody would remember, but. And do you, if you have to get back with it, if you have to, would you please get back on the following, which questions I was asking a while ago about what percentage of people of our votes, of the votes cast, are being cast in this manner, mail-in, and just stick with general election, or to make it easy. I mean, I don't know. You want to do primaries? That's fine too.
I do have numbers for the November 2024 general election. Our team looked at those numbers.
General election or primary or what?
The general election in November. Our team looked at the numbers. About 3.5% of the ballots cast in that election were ballots by mail.
And do you know what it was in 22, or to be, I guess, apples to apples, 2020?
I don't have those in front of me, but we can get
Well,
you
that's going to be skewed, right? 2020 because of COVID. It's going to be. Well, you don't have to answer that, but it's going to be skewed. 2020 was a unique situation, but 3.5 in 2024?
That's correct.
And now, do you have that breakdown, as I asked, as far as disabled, the
We
different reasons they used?
We don't have a full breakdown, but 79% of those were voters 65 or older.
Okay.
We can get you the
So
other
let's say
numbers, though.
80% were over 65.
Roughly, yes.
Yeah. Okay, that's all I got. Thanks.
Ms. Isaac?
So if there are mail-in ballots that are not counted because the delivery date is too late, would it be fair to say that it's possible that more ballots would be actually counted because the delivery time would be extended?
A later delivery deadline would allow ballots that were received after the current delivery deadline to be counted.
So you would have more time for them to be delivered.
Yeah, a later delivery deadline.
So it could result in actually more ballots being counted because you have more delivery time. If that's an issue, which we said that some are not counted because of the delivery date. They were received after the delivery date. So if we extend the delivery date, time period.
For domestic ballots by mail, the delivery deadline is 5 p.m. the next business day after Election Day. If that were later, then ballots that arrived after that timeline would be able to be counted, assuming they were postmarked on time.
Okay. I believe that this could result in more ballots being counted, mail-in ballots being counted, because you have a longer period for them to get there.
So I was referring to the deadline for the ballot to be delivered to the elections office. So if that deadline were later, those ballots that arrived between the current deadline and that later deadline would be able to be counted.
Okay. That's not what I'm saying, but that's okay.
I'm sorry if I misunderstood your question.
Ms. Plesha?
Thank you, Mr. Chairman. Okay, I'm sorry I missed a lot of this, so now I'm really confused. So the bill prohibits early voting ballot boards from accumulating vote totals before noon, 3 p.m., or 6 p.m. on Election Day. Is that right?
That's correct.
Okay. And how does delaying this process improve election security?
I think the idea is, or the bill author's intent is to speed up the timeline to make sure that results are reported in a timely manner. I don't want to speak to the author's intent too much as far as security measures, but I think results reporting timeframes was the intent.
Okay. So then the bill also requires election officials to write multiple notices because we're making changes.
That's correct.
Right, so this is regarding ballot deliveries, central counting station operations, and early voting counting times, right? Okay, so is it your estimation then that these additional requirements will place an undue burden on what we've already heard are overstretched and overworked election officials?
Are you speaking specifically about the notice changes or all?
Yeah,
the timeline
all of
changes in the
these
bills?
changes that now are happening, right? And so we're gonna have to educate voters on these things. Do you think that's gonna cause, more stress, more time, more finances needed on the election officials?
I think the election officials might be able to speak a little bit better about what kind of burdens are placed as far as the timelines that they go through right now. I think in general, we're not talking about necessarily increasing the number of ballots that are counted, but changing the time frame in which that counting's done. They may be able to speak to staffing concerns that might exist there. I think as far as the notice requirements specifically, I think that's a good transparency opportunity to let people know when those activities are taking place and how poll watchers can observe that.
All right, thank you so much. Thank you, Mr. Chairman.
Thank you.
Chairman?
Mr. Raymond?
Yeah, let me, I think I know who's on first, okay? And my sense of it is that there will be fewer votes cast or counted. Mr. Vice Chairman, I agree with you that I believe there would be fewer votes received, cast, counted, all of that if this bill passes. That's how I see it. I know you don't, but I do. To me, what I see here as far as I'm looking at it differently. The debate for me is how important it is to members of this committee and others that we have results in early, all that stuff, or that the other thing to me is, do we want to let ballots come in the next day? That's the issue for me. I certainly think that there will be fewer ballots if this bill passes. However, I want to get results right. I'm not one of those that is so stuck on, oh man, we got to get them, but we got to know the results by 7:01. I mean, I get that. We all run, so we want to know at 7:03 what the early vote results are. I get that. Believe me, I want to know at 7:03 what are the early vote results. But I'd rather get it right, right? So I don't care, honestly, if we don't have the final results till, you know, the next day or a little later, as long as it's all being done right, that legally counted properly, there's no cheating, there's no stealing, there's no stuffing, all of that stuff. And I think we're doing more and more to make sure that doesn't happen, that the ballot, the integrity of the election itself, I think, is strong. So for me, Chairman and members, it's, you know, how much do you care about getting the final count in and done earlier? And how much do you care about ballots coming in the next day? Because if it's about, will there be fewer ballots, you know, and Dennis is my very dear friend, but I believe there will be fewer. And that's just the way I see it. So it's kind of two different things, but it's kind of like we got to decide what do we want to do here. Do we want to let veterans' ballots come in a day later because of where they're coming from and so forth? Do we want those kinds of things to happen? Or do we want to cut that off and get the results in earlier? You know, I said last week or the other day that I was inclined to agree with President Trump when he said recently that, you know, that we should have paper ballots. And I know some members on the committee don't agree with that. But I think where he was coming from and where I tend to agree is I think a paper ballot is more secure than these machines that, you know, with AI and everything else, you can hack into things more and more and more. That's my concern. So anyway, Chairman, I see it a little differently. To me, the issue is not will more ballots come in. I don't think there will be more. I think there'll be fewer. But the real question for me is how important is it for us that we get those final numbers counted earlier? And how important is it for us to cut off veterans and others from being able to get their ballots in a little later?
Ms. Isaac?
So when I'm campaigning, knocking on doors, a lot of times the polls haven't even opened, and I talk with voters that say they've already voted by mail. How long do people have to vote by mail? How many days?
So once you submit an application, the county can send you a ballot by
How
mail.
early can you submit an application before an election?
You can submit a application for ballot by mail at any point in the calendar year that the election is happening, so after January 1st, essentially. So it could be several months in advance.
So you have months
And
to vote by mail.
So the timeline for when the ballot is sent out is kind of what determines when the voter can return it. Counties typically do their testing, programming, preparation of ballots sometime between 60 to 45 days before Election Day. The law requires ballots to be sent to voters, military and overseas voters, no later than the 45th day before Election Day. So as soon as the voter receives the ballot, they have the ability to return it back.
Okay. They think I'm talking about the wrong bill. 1090?
1091.
Oh, yeah, I'm on the right bill. Okay. Okay, so what I'm hearing is we're going to have less people vote by mail when they have months to do it because we're going to short it maybe one day, but we're going to extend the period of time that that ballot can be delivered, which I believe will result in more being counted. So that's where we disagree, it sounds like. So, thank you.
Thank you.
Members, any other questions? Thank you, sir, for being here.
Thank you.
Is there anyone else that wishes to testify on, for, or against House Bill 1091? If not, the chair recognizes Representative Paul to close on the bill.
Thank you, Mr. Chairman. Kind of go through some of all that stuff. Representative Isaac, you can request a ballot by mail on January the 1st of that year, and that way you can receive a ballot by mail for all the elections that would take place in that year. The county sends those out 45 days before the election, so as soon as you get it, you can mail it back. All right, so they got plenty of days to get the mail in. I agree with you that we're going to we will have more time to collect more mail-in ballots because now the post office will have an extra day to do that work. So those ballots that testimony we're saying they weren't collecting was because the post office didn't have time to do them all. So now they're going to have more time to put them on. So you will receive more mail-in ballots with this bill to pass than you did before. And also, somebody had mentioned about the timeline, like I said, going back to that you can go ahead and request this ballot in January 1st. So we're not interfering with anybody's ability to request a ballot by mail. So we're going to actually not have any kind of effect on that. Well, I guess it would change from 315 days from 319 days or something. So I just wanted to address a few of the things brought up in there with testimony. But with that, I close unless there's any other questions.
Thank you, Representative Paul. Any other questions, members? All right, lively, good discussion. If there's no objection, the bill will be left pending. Is there objection? The chair hears none. The bill is left pending.
Thank you, Mr. Chairman.
Thank you, sir.
Vice Chairman. It's always my brother.
See you at the parking lot. We park next to each other. No, we park next to each other.
Just so he gives me space.
Yes.
All right. Chair lays out House Bill 342 and recognizes Representative Hayes to explain the bill. Thank you for your patience, sir.
Thank you, Chairman and members. Last session, Senate Bill 924 was filed and passed in the Senate as amended. I carried it in the House, where we amended and passed it as well, and the Senate concurred, and the governor signed it into law. The intention of the bill was to increase the number of registered voters that could be served at a combined polling location only if a suitable polling location could not be secured in the precinct and if the combined polling place adequately served the voters. Now, what really happened is we have a development in Denton County called Robeson Ranch. It's a senior living center. They have one clubhouse and one restaurant, and all the facilities in one place, but they were so successful, they grew over the years, had more than 5,000 voters, and so they had to split into two precincts. Well, guess what? In the other residential area, there are really no facilities. So this was the theory behind the bill. So anyway, it passed. In the process of doing that, there was some language that was deleted that really shouldn't have been deleted, it seems. So House Bill 342 is a cleanup to Senate Bill 924. Is while it alleviated one problem, one of the changes to the bill had the potential and unintended consequence of requiring some counties to increase the number of polling locations, number of election workers, and equipment due to the effects of county-wide polling locations. So there was wording in the current election code dealing not only with the general rule, which is every polling location, every voting precinct is to have a polling location, but when you have county-wide polling locations, then there is, of course, more combination. House Bill 342 corrects this inadvertent issue by restoring some of the language previously struck, yet retaining the language added by Senate Bill 924. This will help achieve the original goal of allowing counties the flexibility to combine smaller precincts on Election Day to avoid unreasonable expenditures for election equipment, supplies, personnel, and location if the voters are still adequately served by the combined polling location. Thank you, Chairman and members, and I yield for witness testimony and reserve the right to close.
Members, any questions? Yeah, Representative.
Vice Chair, thank you. Thank you, Rep. Hayes, for the bill. So it's not a mandate. It's a cleanup bill that restores language to allow for counties to combine precincts if they see it's better for the voters.
Right. And either the Commissioner's Court or the County Elections Administrator would need to bring forward the suggestion to combine precinct.
Okay. Thank you for the clarification.
You're welcome.
Members, any other questions? Representative, I just have one. I know we worked on this bill last session, and I think what we're doing right now is overturning my amendment. The reason I did it is I was concerned about having fewer polling places. And I think Representative Shaw just brought it up. But it is not a requirement, but this could and likely will result in less polling locations if this bill is going into effect. Is that correct?
You know, anything's possible, Chairman. I would just say that this is recognizing the practicalities. If you do not have a adequate polling location, like in an abutting polling site, that you could combine those two to do it. It's not, the bill requires that there has to be a necessity to do that because of inadequate facilities in the abutting precinct. So it's not like every precinct in the county can decide to combine. There has to be this failure of a proper polling location.
Well, and you have thresholds for smaller counties, it's a range of people, and then it goes up. But ultimately, in reality, this bill is likely to lead to less polling sites. Do we agree that that's probably gonna
I
happen?
know in Denton County, it will require one less.
One less.
Because the intent, again, is since there's no polling location in the voting precinct, it allows that precinct to be joined to an abutting precinct to allow that voting.
And that's your specific issue, but we've heard from people all over, and some are worried about costs and this, and I guess I just have a fundamental problem with the idea that we're gonna close sites because of cost. We've all been talking about how much money the state has. I think fighting for access to the ballot box through our democracy should be a top use of our money. So
Right.
I understand you've got a local practical issue, but it's the statewide impact and the tool that this is gonna close voting sites around the state that is concerning to me.
Well, what this specifically says in the 924 is the Commissioners Court cannot secure a suitable polling location and the location of the combined polling place adequately serves the voters of the combined precincts. So that's what it's doing.
Yeah, I understand, and I'm sure there's gonna be the votes for this. I'm just concerned about how we define that language and who's gonna have it harder time to access the ballot box, but
Sure.
I think we're gonna disagree on this. Thank you, sir.
Members, any other questions? Ms. Plesha?
Thank you so much, Chairman and Representative Hayes. Okay, so now I'm confused again. So the bill allows precinct combinations, but it provides no criteria for what constitutes suitable. Right? There's no definition for what suitable means, and I think that makes it a little vague, obviously. So maybe that's something you and I can work on offline, because I think that loophole could be exploited in the bill. My second question is, as someone who, like I've said before, I run a very competitive race, I knock a lot of doors, and the one thing that I hear a lot from constituents is confusion around, I'm sorry? Oh, perfect. One thing.
No, I'm hearing. I'm just writing down her point about suitable polling location definition.
So my other question is, when we've had situations where a polling locations, for instance, a library is under remodeling or construction or whatever, and so that polling place has gone down and now it's a new location, it's really important for us to make sure that there's transparency to the voters around like what's going on, because like me, I've always voted at the same location for a long time. I always go to the library 2 streets away from my house, and I'm emotionally attached now to that voting place. I know the people who work that poll and all kinds of stuff, right? So what I also would like to see in this bill is kind of some advanced warning or notice to constituents when their precincts are combined. Right? Because if we're going to have an outcome of less polling locations, then we should let our constituency know, hey, your, tried and true polling location that you've been voting at for 25 years, it's not going to be there anymore.
Yeah, I think, again, we're speculating as to something that's going to happen. The bill is designed that there's not a suitable polling location. It just doesn't exist. So you're going to have to go find somewhere where you can do it. So you're going to go next door. So not knowing the geography of that particular library location, I don't know what other locations are there. But there are provisions right now under the election code that require the posting of all polling locations X number of days in advance of the election identified by precinct number. I think those deadlines have worked pretty well over the years. I'm like you, I always go to the same place and vote each time, but in your case, there was apparently a library remodel going around, so they had to go find another suitable location to do that.
Yeah, so those are just some thoughts that I've had while we've been listening to the conversation. Thank you so much, Representative, for bringing this. Thank you, Chairman.
You bet. Members, any other questions? Okay.
Thank you.
Did you have a question? Okay. Okay, we will proceed to testimony. The chair calls Andrew Hendrickson with the ACLU of Texas. Okay, give him an opportunity. Chair calls Susan Valiant, representing herself. Hello, ma'am. I show you registered as Susan Valiant, representing yourself, and you are testifying for the bill?
Yes, sir.
Okay, well,
sir. Thank you,
welcome. Welcome
Chairman.
back, and please continue.
Thank you. Yes, in his response to his question about having fewer polling locations, that would be true, especially in Tarrant County. It's kind of something that we want to get towards because it's a more fiscally responsible. The reason, I mean, right now as it stands is we have to have one polling location for every 2 precincts. So 50% of all our county has to have at least a polling location in 1 and 2. And so with combining, we could actually have 3 to 4. The only thing that is missing in this bill is that all this applies to counties that have less than 1.2 million population. That excludes Tarrant County, Dallas County, Harris County, Bexar County, and fixing to be Collin County. They're not quite there as far as the population goes yet, but so that's something that we're forced to do countywide voting, and that's another issue too. Is that the polling locations are dispersed in countywide voting disproportionately. So, I mean, you could have one polling location that's right across the street from another polling location, but then you don't have one for this location out here. So if you have precinct voting that are combined, it's more appropriately dispersed. Does that make sense? So that's all I kind of wanted to answer your question as far as, yes, it would. That's what we would like to get to is fewer, but yet more appropriately dispersed throughout the county.
Ma'am, I wanted to actually clarify, you're actually here representing yourself, SREC, SD10.
I'm SREC SD10 committee. And
yeah, let me read it to you, and then you can tell me
sorry.
if I'm accurate. No, that's perfectly fine. So you're Susan Valiant. You are representing yourself, SREC, SD10, Texas First Election, and yourself again.
Yes.
Okay, great.
Yes,
and
I didn't.
And you are testifying.
I was doing it on my phone, and I couldn't.
It was actually my mistake, not yours. So you're doing great. Members, any questions? Thank you, ma'am, very much for being here. Yeah, you bet. Chair calls Jennifer Doinoff with the Texas Association of County Elected Officials and self. Okay. The chair calls Dr. Laura Presley with True Texas Elections. There's a typo there for a minute. Okay. May I show you register as Dr. Laura Presley with True Texas Elections, and you are neutral on the bill?
Yes.
Okay.
I like the bill. I think it actually touches on a very serious issue with regard to ballot secrecy. The Secretary of State has testified in the past that when we have these small precincts, that if you're a voter that votes in it and you're the only one at that location, your ballot is breached by design, by definition. So by getting rid of these smaller precincts and combining them with larger precincts, I think that helps the ballot. Actually, this handout's for a different one, but that's okay. You can go ahead and... Yeah, there's another one on that. So what I would like to plant the seed on is that we have a limit, a lower limit for precinct with registered voters. I think we have an upper limit now. But I would like you guys to consider and maybe put in this bill as an amendment a lower limit for precincts. And that would really preserve our ballot secrecy on purpose so that we're not, and when you combine these precincts, you have a larger pool and you have a less opportunity for a single person, a lone person from that precinct voting, either ballot by mail or early vote, countywide, or whatever. So I want to plant that seed. The reason for ballot secrecy breaches for early voting and on countywide is because of the code. In the early vote code, it says that a person for early voting is able to vote anywhere at any early vote site. That, by design, breaches ballot secrecy. And that's on you guys. That's on the legislature. That's a law that I would say is unconstitutional and is ripe for a federal lawsuit. Countywide is the same thing for Election Day, that you allow countywide. Now, the county commissioner's court approves that, but you guys open the door for them to walk through. Again, that situation is it by design breaches ballot secrecy for 1 to 5% of the voters. So I'd like you to consider having a lower limit and getting rid of the early vote sites open to everybody and getting rid of the countywide that's open to everybody and combine the precincts. You could do contiguous precincts with a certain limit, maybe 5,000 to 15,000 registered voters, and now you're preserving our ballot secrecy. And you guys, our laws are not in violation of federal law. So I want to plant that seed.
Thank you, ma'am.
Bless y'all. Thank you.
Members, any questions?
I'm here if there are any questions. Okay, thank you.
Thank you, ma'am. Chair calls Laura Rogers with the County and District Clerks Association and also representing herself. Welcome, ma'am. I show you registered as Laura Rogers, representing County and District Clerks Association and yourself, and you are testifying for the bill.
That's correct.
Thank you. You may proceed.
Thank you. I am Laura Rogers. I'm the County and District Clerk for Sherman County. I'm also the Legislative Chair over elections for the County and District Clerks Association, and we are in favor of this bill. SB 924 had some unintended consequences that this bill will correct. November 2024, we actually had a lesser voter turnout than we did in 2020 with the more polling locations open. So our association always supports being a good custodian of our tax dollars, and I believe that this bill does just that. Thank you, and I'd be happy to take any questions.
Thank you, ma'am. Members, any questions? Thank you so much for being here. Chair calls Ed Johnson with Harris County Ballot Security and yourself. Hello, sir. I show you registered as Ed Johnson, and you are representing Harris County Ballot Security and yourself, and you are testifying for the bill.
Correct.
Thank you, sir. You may proceed.
Yeah, let me go back a little history. I don't remember the bill that was passed last session, but it was by Senator Springer and Hall here. Hayes here. What they were trying to do is clean up the election code for unintended consequences in it. And where he was talking about you have this, retirement community that doesn't have polling locations, you have to combine it with something else. Well, you were breaking the election code when you had to do that. When I was running elections in Harris County or working on elections in Harris County, we broke this code every election, okay? Because there are precincts that you don't have polling locations for and you had to combine. So it's actually, what ended up happening is there was an amendment to the bill and it increased the size for the 10,000 and it was misplaced into the code and it put it to where counties over 1.2 million could no longer combine precincts together. So this happened right before the primary, and they were no longer able in the primary runoff to do combinations in all the large counties. So they had to open a poll in every precinct, which was just outrageous and didn't have enough equipment for. So this bill fixes a very, very serious problem that we need to fix to put that back in place. But we're putting back things that y'all were trying to fix the session before of not allowing to combine precincts together. Section B says a county over 250,000 cannot combine a precinct that's over 750 voters. That is not a very large area. I mean, there are precincts in Harris County and other places that are 1,000 voters that don't have a polling location. And it is defined in the election code what is an adequate polling location. This is in the chapter before this one. It describes what you have to have an adequate polling location. So really we need to take Section B out of here, and I would say, allow counties to combine up to the max of 5,000. Two simple amendments. You would take Section A, where it says 500 voters limit, and change that to 5,000. You could take Section B out. And then you would be on the same equal playing ground as what you are in Section D, where you're allowing counties doing precinct voting to combine up to 10,000. This would allow counties doing countywide voting to combine down to 5,000, and then they can cut that number in half during countywide voting, and they would actually be at that 10,000 number too. It would make both of them the same. So I would love to see an amendment to it of change Section A to 500 to 5,000. You take Section B out, and then everything is wonderful. And we're abiding by the law then.
Thank you, sir. Members, any questions? Thank you, sir,
Thank
very
you.
much. Chair calls Catherine Kano, representing herself. Hello, ma'am. I show you registered as Catherine Kano. You are representing yourself, and you are testifying for the bill.
That's correct.
Thank you, ma'am. You may proceed.
I think it's a really good bill. I think it does address this issue that was created as an unintended consequence. I know in Tarrant County, it affected us this last election cycle. We had to scramble to find not only locations, but also election workers. At the last minute, it was difficult for us to do, and we sort of barely scraped by. As Ms. Valiant pointed out, it will help counties be more fiscally responsible. It may result in fewer polling locations, but I think that's something you kind of need to discuss with your county election officials, because speaking for Tarrant County, I have been involved with discussions in primaries and general elections about how these locations are chosen, where they're situated. There might be a reason that two polling places are within close distance to each other, and the reason for that is often overflow. There's too many voters at one location, so if you situate another polling location close to it, you can account for that. But those are things that I think are best left to the discretion of the people who are running the elections in those counties, because they have the most information available, and that is, their job. They're experts in that. So the only concern I would have about this is that I think the committee should make an effort to talk to elections officials in smaller counties and make sure that this wouldn't have any unintended consequences there.
Thank you, ma'am, very much. Members, any questions? Thank you, ma'am, for being here. That is everybody that's registered. Does any member want a resource witness? Okay. All right. Is there anyone else who wishes to testify on, for, or against House Bill 342? If not, the chair recognizes Representative Hayes to close on his bill.
Thank you, Chairman, members of the committee. Thank you for your comments. Representative Busey, I'll get with you, and same thing with you, Representative Plesa, to see if we can't address your concerns. Because remember last time you did have an amendment, Representative, and I was fine with your amendment. And I'm hoping that we didn't do something to try to undo that. But if somehow in redoing this, we'll figure out a fix. Thank you. Thank you.
Members, any other questions for the representative as he walks away? If there's no objection, the bill will be left pending. Is there objection? The chair hears none. The bill is left pending. Chair lays out House Bill 614 and recognizes Vice Chair Busey to explain the bill.
Thank you, Mr. Chairman and members, for allowing me the privilege to lay out House Bill 614. House Bill 614 would repeal the limited ballot process and instead allow voters who have moved to a new county the ability to cast a provisional ballot either during early voting or on Election Day at their polling location. This would allow a more robust review process by the early voting ballot board, ensuring a more safe and secure election. Upon a voter casting a provisional ballot, the voter registrar will confirm that the voter has an active registration in the former county, has filled out the statement of residency in the new county, and has signed an affidavit acknowledging that voting more than once is a felony. Clerks already upload early voting, election day voting, and mail-in ballots to the Secretary of State the day after they are cast. This allows the early voting ballot board to easily and securely verify that the voter did not vote in their former county before counting the ballot. By ensuring voters are voting in the proper county, we are upholding election integrity. Additionally, these voters will no longer be constrained to a limited ballot and can vote in all statewide, district, county, and county races represented by their new residents. House Bill 614 principally serves two purposes: ensuring voters who recently moved vote in their county or residence, and ensuring proper list maintenance and updated voter rolls. I want to thank you for hearing this bill, Mr. Chairman. Happy to answer any questions, and I reserve the right to close.
Thank you, sir. Members, any questions for Vice Chair Busey?
Thank you.
Hearing none, we'll proceed to testimony. Chair calls Taylor Trevino with the Texas Civil Rights Project. Hello, ma'am. I show you registered as Taylor Trevino. You are representing the Texas Civil Rights Project, and you are testifying for the bill.
Yes.
Great. You may proceed.
All right. Chair Shaheen, Vice Chair Busey, and members of the House Elections Committee, my name is Taylor Trevino, and I'm here representing the Texas Civil Rights Project in support of HB 614. HB 614 would solve a problem that plagues thousands of Texans every election cycle: limited ballots. Every election, we get voters who move sometime between the registration deadline and the election, either out of their county for countywide polling place counties or out of their precinct for precinct-only voting counties. These voters are only allowed to vote a limited ballot during early voting, but can't vote otherwise. HB 614 solves that problem by allowing a voter to update their voter registration at the polling place and submit a provisional ballot at any polling location in their new county. TCRP is part of the Election Protection Coalition's hotline 866 Our Vote, and one of the calls that we consistently get is from voters who are confused about how to cast a ballot after they've moved. Giving voters the opportunity to vote a full ballot at any time during the election will help so many voters who would otherwise get turned away on Election Day. As an extra bonus, HB 614 would also help keep our voter rolls accurate by allowing updates to voter registration in real time so that our poll books are current. We ask the committee to please report HB 614 favorably and solve the limited ballot bottleneck with a common sense solution. Thank you.
Thank you, ma'am. Members, any questions? Thank you for being here.
Thanks.
Chair calls Jennifer Doinoff with Texas Association of County Election Officials. She's not here. Chair calls Fernanda Maladano with Move Texas. And yourself. Welcome, ma'am. I show you registered as Fernanda Maladano, and you are representing Move Texas and yourself, and you are testifying for the bill.
That's right.
All right.
Move Texas Civic Fund.
Okay, welcome. Go ahead.
Thank you. Good afternoon. My name is Fernanda. I am the Civic Engagement Director with Move Texas Civic Fund, speaking in favor of House Bill 614. In my position, I've been through over 5 years of election cycles where I have personally spoken to hundreds, if not thousands, of students on any given election who would stand to benefit if this bill were passed. Through our work, we've learned to operate within the parameters of an archaic, outdated voter registration system in order to ensure that as many eligible young Texans have a voice in influencing their communities, be it through national, state, or local elections. Those complications are often compounded by the fact that the actual process to cast their ballot is further mired by barriers that are a result of policies that get decided and enacted in rooms like this. Every single election, I encounter multiple students who, either by lack of understanding or foresight, or simply because their voter registration didn't go through as a product of our paper-based voter registration system, are not able to participate in the most basic and fundamental of democratic processes. As a result, this past election, I spoke to students and election workers at UT Austin campus to express concern about the fact that they had to turn away multiple students away from the polls during a presidential election, no less, because they were not able to update their voter registration before the deadline. Limited ballots during early voting is an option, but it is an incomplete solution. It only allows students to vote on part of the ballot. It's not available on election day when most people vote, and is only available in single polling location in the city. This process places an undue burden on students, forcing them to overcome multiple layers of challenges just to cast a partial vote. Provisional ballot, namely through this bill, expands the access to the ballot and overcomes the challenges that the current process imparts. It allows young voters to vote on their entire ballot, is available at all voting sites, and is open throughout the entire voting period. I specifically speak on behalf of first-time voters, people who, like me, once upon a time were not taught the intricacies of the way voter registration works in Texas, people who, like me, once upon a time thought I could show up to the polls and didn't know that I needed to go out of my way to update my voter registration every single time I moved. And for those reasons, I urge the committee to vote yes on HB 614. While we may be ways away from a same-day voter registration process that other states have adopted, this might be the closest we get to it. This might be the closest thing we get to spare a young person the devastation of being turned away at the polls because of circumstances that may be out of their control. And this could actually be a step towards improving the experience for young voters who simply want to make their voice heard. Thank you.
Thank you, ma'am. Members, any questions? Thank you, ma'am, for being here.
Thank you.
Chair calls Catherine Cano, representing herself.
She had to leave.
Okay. Chair calls Ed Johnson with Harris County Ballot Security and yourself. Is there anyone else who wishes to testify on, for, or against House Bill 614? Yes, ma'am. Will you please come over and Haley will help you register? I'm sorry. Wait, ma'am, hold on. We have a question.
Yes, I registered, but I didn't do oral testimony, so.
Oh, okay. What's your name?
Marlisa?
Chair calls Marlisa Maran with Common Cause Texas. Ma'am, I show you registered as Marlisa Maran with Common Cause Texas, and you are testifying for the bill?
Correct.
Okay, you may proceed. Thank you.
Hello, Chair Shaheen, Vice Chair Busey, and committee members. My name is Marlisa Marin. I am here to testify in support of HB 614, a bill that helps expand voter opportunities for eligible Texans. In my role as Election Protection Manager with Common Cause, I help run the Nonpartisan Texas Election Protection Program. This program provides firsthand experience to the challenges that voters face. Our legal hotline got calls from Dallas, Tarrant, Harris, Hidalgo, Johnson, Victoria, Fort Bend, Bell, Bear, and many other counties from voters who had moved and were worried about their voter registration status. Allowing Texans to cast a provisional ballot during early voting and on Election Day after moving to a new county would help remove barriers that often prevent them from voting. This bill would make the process more accessible and ensure more Texans can participate in our democracy. A 2024 study found that Texas led the nation in intrastate moves in 2023, with 3.3 million people relocating. This means that millions of Texans had to update their voter registration, and many likely did not, resulting in countless Texans likely being unable to cast their ballots. Under this bill, election officers would also serve as voter deputy registrars. Currently, voters who are not registered are simply turned away. This bill would change that by allowing eligible Texans to register on the spot, ensuring that they do not leave with disappointment, but with the ability to participate in future elections. In summary, this bill expands voter access for Texans. In a state with some of the lowest voter turnout rates, all legislators should be focused on making the ballot box more accessible. We ask you to please pass this bill. Thank you for your time.
Thank you, ma'am. Members, any other questions? Thank you for being here.
Thanks.
Is there anyone else who wishes to testify on, for, or against House Bill 614? Yes, sir.
I'm sorry, I probably missed my name, Ed Johnson.
Yeah. You can come forward, Mr. Johnson. Sir, I show you as Ed Johnson with Harris County Ballot Security and yourself, and you are testifying against the bill.
That is correct.
Okay, thank you. Please proceed.
I guess the problem, or what this bill is actually doing, is making same-day voter registration in an election, because you're able to go to a new county that you're not registered to vote in and vote a provisional ballot on that day. And there's nothing in the bill saying that the provisional ballot is not going to be counted. So, and this actually skirts the voter registrar's ability to be able to adequately process that voter registration application that's on the provisional ballot in a timely manner like they are all other ballots. They're given 7 days to make a determination, and then it's sent to the Secretary of State's office, where they're given another 5 to validate it against the driver's license list to make sure all the information is correct before it's sent back and you're registered. That's why you have a 30-day process or 30-day period to register to vote. There is safety checks that are put into this voter registration system, to ensure the information is correct and accurate. I would see that this bill would possibly bypass those, and you're going to have people registering to vote that may not be entitled to vote and get to cast a vote on election day. A big problem that we have in same-day voter registration in other states. So this is just a form of same-day voter registration.
Thank you, sir. Members, any questions? Thank you, sir, for being here.
Thank you.
Is there anyone else wishing to testify on, for, or against House Bill 614? If not, the chair recognizes Vice Chair Busey to close on his bill.
Yeah, just to speak to the last statements, that's just inaccurate. This is not new registration. These are registered voters in Texas. They are in a new county, and right now they're voting a limited ballot. So they're voting for statewide or whatever. We're saying let them vote in the entire ballot. And just to be clear, they are going to fill out an affidavit under this bill. I am currently registered to vote in blank county and have not cast a ballot in that county in this election. I understand that doing so is a felony of the second degree under Section 64.012 Election Code. This isn't going to be a back channel for same-day registration. They're going to fill that out consciously knowing that they are committing a second-degree felony if they're trying to manipulate this. It's making sure Texans get to vote. We're talking about a lot of people are moving around this state. These are registered Texans, so I just want to refute those last statements that are inaccurate. It's not new registration by any means. It's still going to be reviewed. It's going to happen after the process to make sure not only did they swear this oath, which has been an ongoing issue in this committee, is what are people's intents and knowledge. They are guaranteeing their intent and knowledge, and we're going to verify that they have not cast their vote in their old county. So this is a way to make sure more Texans get to participate that are already registered. And with that, if there's no other questions, Mr. Chairman, I close.
Thank you, Vice Chair Busey. Members, are there any questions? Hold on, give me 1 second here. If there's no objection, the bill will be left pending. Is there objection? The chair hears none. The bill is left pending. Chair lays out House Bill 521 and recognizes Chairman Guillen to explain the bill. The chair offers a committee substitute.
Thank you, Mr. Chairman.
Yep.
Members, ensuring that every eligible voter has fair and equal access to the ballot box is one of our most fundamental responsibilities. While current law allows for curbside voting for those physically unable to enter a polling place without assistance or risk of injury. Gaps in the process have led to inconsistencies, inefficiencies, and concerns about election security. Unfortunately, many individuals are unaware of the requirement for the eligibility of curbside voting, often treating it like curbside shopping, and thereby complicating access to eligible individuals who really need it. Members, as you'll hear today, in my neck of the woods, the voter assistance tool meant to support vulnerable populations in exercising their right to vote has been abused. During the last election cycle, many of my constituents were left frustrated by the actions of some local candidates who went as far as serving as voter assisters themselves, even entering voters' vehicles to assist them in casting their ballots. This abuse of the system has raised serious concerns within the community, and it's imperative that we take steps to rein in this type of behavior and restore integrity to the process. With that in mind, House Committee Substitute to House Bill 521 requires voters using curbside voting to complete a form affirming their eligibility for curbside voting. It also requires 2 election officers to be present when providing voter assistance at the curbside, just like we currently do inside the polling station. It requires individuals transporting 7 or more voters during an election to document their assistance. It adds election officials to the list of individuals who are required to document that they assisted a voter, and it requires all individuals who assist 7 or more persons to document their assistance on a separate form. And it establishes a Class A misdemeanor for failing to complete the required documentation for voter assistance. The committee sub differs from the original bill. It makes several key changes from the original bill to refine its provisions and strengthen election security while maintaining accessibility for curbside voters. The primary differences, besides it just being a Ledge Council draft, are that it removes the oath requirement, and it refines the language on the form, and it removes the penalty on the sworn statement, and undid the changes to the unlawful assistance statute. Members, the committee substitute to House Bill 521 balances accessibility and election integrity. It ensures that voters with disabilities continue to have access to curbside voting while adding necessary safeguards to prevent misuse. The bill clarifies the responsibilities of election officials, requires proper documentation for voter assistance, and strengthens enforcement to uphold public confidence in the process. We're currently working with stakeholders who came to us in the past couple of days on another committee sub to refine some of the language and address some additional drafting areas that we found. I'm happy to answer any questions.
Thank you, Chairman Guillen. Members, any questions? Vice Chair Busey.
Thank you, Mr. Chairman. Thank you, Chairman Guillen. We spoke on the floor today, and I appreciate that. You helped me pass the omnibus bill to help disability voting last session. I'm a little worried about some of the side effects. I think your unintended consequences that could happen with the bill, I need to look more closely and continue to work with you on the committee sub. So the main thing I'm saying is I appreciate your openness today as we're working through it. I'm guessing we're going to hear from some of the disability rights groups. I just want to make sure that they have a seat at the table because you talked to me about a specific issue you're having in your area, and I understand that, and we want to make sure people aren't abusing the system. I'm just worried about the unintended consequences. So I just hope before we move this bill, we'll continue to work and work with those groups. So thank you for that commitment.
I appreciate it. I agree. We don't want to keep disabled people from accessing the ballot.
Thank you, sir. Thank you.
Mr. Raymond?
So to be clear, so this bill would make it harder for disabled people to vote?
No, sir. No, sir. I mean, no, we've got a problem, and we're trying to address it. And this will make it harder for people who abuse the system to abuse the system.
That's what I got the confused. Make it harder, but harder for the bad guys.
Right.
Okay. All right. Okay.
I can't help
Any other questions, members? Yeah, really. Thank you.
Thank you.
And you reserve your right to close.
Appreciate it.
We will proceed to testimony. Chair calls Maria Hernandez, representing herself. Hello, ma'am. I show you registered as Maria Hernandez. You are representing yourself, and you are testifying for the bill.
Yes, sir, I am. Thank you.
Great. Thanks for being here. You may proceed.
Hold on. Good afternoon. My name is Maria Yvette Hernandez, and I'm a resident of Starr County. I'm here today to speak in support of this bill and impress upon you the impact assisted voting has had on local elections in our area in recent years. After COVID, curbside voting morphed from preventing infection and providing safeguards for health to a type of fraud that not only disenfranchised the most vulnerable, but also violated the rights of employees and county workers. Today, not only do we see vote harvesters assisting the elderly and disabled, but candidates and incumbents running for office assisting municipality employees to ensure they vote a certain way. Due to the lax documentation requirements, there is no way to track how much abuse takes place. In recent local elections, we have seen judges who are still presiding over cases being assisted by candidates or politiqueras. We have seen municipality, school district, and county employees all be forced and taken to the voting polls and assisted by candidates or politiqueras. Creating a bill that specifies what actions make it criminal sets the foundation for prosecution later and fraud prevention. However, I believe that it's also imperative that we not allow those that most benefit from this abuse and fraud to have prosecutorial discretion over them. It should be the state and federal authorities. As we speak, right now, our local DA sits on an extensive criminal investigation that implicates a large scale of majority office holders, and in our county, like most others, the parties most responsible for perpetuating these types of abuses are elected officials and candidates. Vote harvesters and politiqueras are just their pawns. I urge you to please consider passing this bill as it lays down the foundation for enforcement. Thank you. Do you have any questions?
Thank you, ma'am. Members, any questions? Thank you, ma'am, for being here. Yes, sir.
I do have a kind of it's not clear to me who qualifies, and I don't know if Secretary of State needs to as a resource, like who can do curbside these days? That's not clear to me.
We can, if you want, after all the witnesses that are registered, we can have the
Okay.
resource witness come up. The chair calls Tony Trevino, representing yourself. Hi, I show you registered as Tony Trevino. You're representing yourself and you are testifying for the bill.
That's correct, sir.
Welcome. You may proceed.
Thank you. I'd like to thank the members of the committee and Representative Guillen, and I wholeheartedly support this bill. My name is Tony Trevino. I'm a former federal prosecutor, and I'm the current Starr County Republican chair. As county chair, I recruit election workers and poll watchers for various elections, and I've also worked in these capacities. I've learned of two abuses of curbside voting, two abuses in curbside voting in two different areas. One are young people who are using it as a form of drive-by voting, and the other area involves politiqueras. I've learned that the vast majority of people are unaware that a voter has to be eligible to vote curbside, statutory. The eligibility for curbside voting is spelled out in Section 64.009A of the Texas Election Code, which states that if a voter is physically unable to enter the polling place without personal assistance or likelihood of injuring the voter's health, on the voter's request, an election officer shall deliver a ballot to the voter at the polling place entrance or curb. This bill would require that a person seeking to vote curbside would actually have to take an oath that they're eligible. That's all it does. This requirement serves to educate the voters that there is an eligibility requirement, and I would like to still believe that young people and others who become aware of this eligibility requirement will not make a false oath and will instead go inside the polling place to vote if they are not eligible for curbside voting. Taking such an oath is not unusual or uncommon, as each voter who submits an application for a ballot by mail also has to sign an oath. They sign oaths that they are eligible to vote by mail. And as a matter of fact, they're required to specify the exact reason they are eligible to vote by mail. For example, are they over 65? Are they disabled? Are they within 3 weeks of giving birth? That brings me to another part of this bill as it regards assistance. Oftentimes, voters are driven to the polls by politiqueras, paid political operatives whose job it is to deliver votes for a candidate or candidates who've hired them. In Starr County, over the course of an election, one politiquera may drive 50 to 100 or more people to the polls to vote. And in order to ensure that they deliver the vote for the candidate who they're working for, the politiquera will tell the voter to ask the politiquera to assist them at curbside, and also to make sure that they vote curbside and that they ask for their assistance. So this oath to vote curbside actually empowers the voters to know the law and to know their rights.
Thank you, ma'am. Members, any questions? Mr. Raymond?
Yeah, so, right now, somebody drives up, right? Like if my mother were gonna go, she would have to, she can't walk at this point. So I'd drive her up, let's say I drive her up, right? And, you pull up, so election clerk comes out, right? This is before I'm talking about currently, before this bill.
Okay.
The current practice, if you will. And so I'm sitting there in the driver's seat, my mother's sitting in the passenger seat, right? And the election clerk then gives them the ballot, says, here's a ballot.
Well, they still have to qualify them to vote, so they still have to go through the same
So
regular
they say,
process.
okay, you're over 65?
No,
You're
they're-
disabled, what do they say?
No, they just ask them for their driver's license, and they go in and make sure that they're qualified to
Okay,
vote.
that part,
Then they come back out with the ballot.
yes.
And if they do it properly, you should be asked to exit the vehicle unless you're assisting
Well, that's where I
your
was
mother.
going.
Yes.
That's where I was going. It's like, all right, so under current law,
Mm-hmm.
I'm supposed to be asked by the election clerk, hey, get out of the car? Is that right?
That's correct. They
And
should,
are they not doing that in Starr County or what?
oftentimes they do not do that.
So the election clerks are not doing their job?
Oftentimes they feel pressured to
Who's-
allow the
who's
people
they?
to stay in the cars.
The election clerk
Yes, the
feels
clerks.
pressured by whom?
By the politiqueras, by the other people. Recently, there were 5 people in a vehicle that when I was poll watching, there were children and 5 people in a vehicle. 2 or 3 of the men got out, 2 of the women stayed in. The men came back, and then they brought the voting materials out, and all of these people were all in the vehicle while 2 of the women
So
were voting.
under current law, and I apologize that I don't know this, I just, I haven't really done that kind of program, right? I mean, we try to encourage people to go to vote and all that, but, so, under current law, they drive up, they're supposed to tell them, please get out of the car? Is that right?
Yes, whoever's not the one
Maybe
voting.
if it's in the back seat, they got a 2-year-old strapped in, and probably that's okay?
That
Or
would
not?
be fine.
Or maybe they're minor or something like that. But
Right.
they're supposed to ask them to get out.
Right, as
And they're
long
not-
as they're able to get out. If you
Yeah, well, if you're
had
driving,
3
you
elderly people that were in the vehicle, you would just ask them not to be communicating with one another while they're voting their ballots.
All right, so they're not, you feel like they're dropping the ball on that in Stark County?
Oh, definitely.
They're just not telling them, hey, get out of the car?
And then the voters are also pressured into asking the person who drove them, the politiquera, they're pressured by them to say you want to vote curbside, and say you want for me to assist you. And that's what they do.
So the voter is being pressured by the politiquera to say that?
That's correct.
Okay. And so were this to pass, now let's say this passes, tell me how what you see.
Well, number one, the voters would realize that if they're able to get up, if they want to get up and go and vote in the polling place, they really should not be voting in their car. So they
Because if
should
this
get up.
passes and the voters the election clerk's gonna say, how do you envision it playing out?
Well, right now.
Let's say you're an election clerk, right?
Right.
Okay, go ahead.
Then I would simply go out and I would ask them whether or not they wanted to vote curbside. If they said yes, then I would say, I need you to sign this oath, and I would read the oath to them, which would basically say, I certify that I'm eligible to vote curbside, that I cannot go inside without risk of physical injury or fear that I'm going to harm myself. And then they would sign. But
And-
most people don't know that you have to be eligible. They
Well-
think anybody can drive by vote.
Well, again, so under current law, the election clerk is not doesn't say anything to them about it
No, and they're not even allowed to say anything to them about it
under current law?
under current law.
So does this, and I apologize that I don't know this, but does this bill, or does the way the law is already, does it contemplate saying it in English and in Spanish?
Oh, definitely. I mean, it doesn't specify that, but everything that we do in Stark County is in English and in Spanish.
Well, but that, yeah, but if it's not the law, then they don't have to. I'm trying to get to.
Right.
My mother's from Stark County, so I know Stark County well.
Okay, all right.
So I think we probably should put something in there, and I'll tell the author that, I don't know, if it's clear to the election worker that the voter, I mean, if you drive up and they start saying, no, sí quiero votar aquí en el carro porque no puedo andar muy bien, you know, something like that, then that sort of the law would compel them, the election clerk, to tell them in Spanish, tiene que firmar aquí indicando que no puede andar, or no puede entrar, or whatever, right?
I think in Texas that it's required, that statutorily required that everything in Texas elections has to be
Well, that's what I
available
was
in
getting
either
to.
English or Spanish.
If it's already the law, then, okay, we're covered. I want to make sure
Right.
that, I think you'd want to make sure, right?
Yes,
Otherwise, it's not going to go well with, I think, a lot of people.
right.
So, are you telling them, and am I reading this right? So they're signing this under penalty of perjury or something?
Well, anytime that you're going to swear, and anytime you're signing something under oath, yes, it's under penalty
But
of
I'm saying,
perjury.
are you saying that to the voter?
Yes.
Is that what the bill is? You're the clerk, remember, you're the
wording that
election
it has
clerk.
right now is that they have to sign a form, I swear or affirm under penalty of perjury that I'm physically unable to enter the polling place without personal assistance or likelihood of injuring my health, and that I'm requesting to vote outside the polling place.
Okay,
Thank you.
thank you very much.
Members, any other questions?
Thank
Thank you,
you.
ma'am, very much. Chair calls Debbie Garza, representing herself. Hello, ma'am. I show you registered as Debbie Garza. You are representing yourself, and you are here to testify for the bill.
Good afternoon, Chairman
Is
and
that
all the
correct?
members.
I'm sorry.
Huh?
Is what I said correct?
Debbie
That you're
Garza?
Debbie Garza, you're representing yourself, and you're here to testify for the
Yes,
bill?
sir.
Great, thank you.
My name is Debbie Garza, and I'm native resident from Rio Grande City. I am for today here to support the bill. I've been a politiquera for so many years. I get to know a lot of people doing that and help a lot of people also. I've been involved in the elections campaign, working with candidates. I worked last candidate with Ms. Yvette Hernandez when she ran for Stark County Judge. The elections determined by the margins created by these votes. Candidates instruct politiqueras like me to go after the older people and disabled voters, not for their help, if not for themselves. We convince them that you have to vote for a certain person. They're old, they don't really know sometimes to read or write, and they go and do as we say for the candidate. And sometimes even the candidates go inside the car to make sure that the person is voting for them. And we as politiqueras get paid cash. There's no report tracking the numbers of workers and money paid made. It's almost impossible to get track of all the money we get paid. This bill is important because it sets the guidelines that protects older people and disability individuals who make sure the vote is on their own. There's a lot of fraud that goes in on the elections. And that's one of the reasons I'm supporting the bill.
Thank you, ma'am, very much.
Thank you.
Members, any questions for the witness? Ma'am, thank you so much for
You're
being
welcome.
here. Chair calls Marliza Maran with Common Cause Texas. Okay. Chair calls Kathy Hagler, representing herself. Hello, ma'am. I show you registered as Kathy Hagler. You're representing yourself, and you're here to testify for the bill?
Yes, Mr. Chairman, that's correct.
Okay.
Thank you. So although I am representing myself, I have been employed by several election integrity organizations over the years where we've received calls from people to answer questions or hear reports when people think something wrong happened when they went to vote at the polls. I'm not speaking on behalf of those organizations. I'm just telling you some of the kind of calls that we've gotten. I have taken testimony from election judges and clerks who believe that they had voters who were not disabled in any way, but were using the curbside voting to jump the line and cut and get finished voting sooner. But under current law, as Representative Raymond asked, we are not allowed to ask them why you're curbside voting, not allowed to question it. One person told me that the voter in the vehicle was a strapping young man who was probably 20 years or so old or so, and he acted like the curbside voting was a big joke and he was just trying to see if he could get away with it. He laughed all the way through it. Again, we are not allowed to question why a voter is voting curbside. And we even got a call one time about an election judge who was trying to be helpful. This was in 2024. Trying to be helpful and took the curbside voting equipment across the parking lot to the senior citizen exercise class and offered to let all of them vote curbside just to save them from having to wait in line. Since none of those people had requested it, that was illegal. We advised them so, and it stopped, not soon enough though. So there's a lot of abuses there with curbside voting. So I believe Tony already read the requirement of the oath, what it says, under penalty of perjury, I'm not able to do this physically or I could get hurt. That's what I like about this bill. We finally have the voter having to say something and agree to something that tells us, we can't ask them, but now we're making them tell us that they're unable to come in and vote. And of course, there was an election contest last year as well where votes were thrown out because of the illegal assistance to the voter. And we say all the time, we want to make it easy to vote, hard to cheat. But it grieves me that an innocent voter went to vote and their vote was taken out of the vote count because an election worker gave them illegal assistance. That's not the voter's fault because they didn't know. Now with this oath that we're proposing, they'll know. So please support the bill. Thank you.
Thank you, ma'am. Members, any questions? Thank you, ma'am, very much. Fine. The chair calls Mary Ibarra with ACLU of Texas. Hello, ma'am. I show you registered as Mary Ibarra with ACLU of Texas, and you are here to testify against the bill?
Yes, I am.
Okay, thanks for being here. You may proceed.
Good afternoon, representatives again. My name is Mary Barra. I'm a voting rights strategist representing the ACLU of Texas. I'm also a Rio Grande City native, born and raised. And I'm testifying in opposition to HB 521. A voter should never have to have the burden of proving their disability. This opens the door for increased discrimination against a community that already faces barriers in exercising a right to vote. Many disabilities are invisible. Someone may be physically unable to enter a polling place on election day, but may be able to on any other day. This is not uncommon for people with chronic illnesses and chronic pain. Secondly, this bill creates several Class A misdemeanor election offenses for voters and election officials. fines which could be up to $4,000. With these new requirements, it is highly unlikely that there won't be any mistakes made when filling out this new form, especially by election workers who, as part of their job, see a lot of voters that are likely to be asked to assist over 7 voters and now must keep track of the number of voters they have assisted so they can fill out this form accurately. We shouldn't want people to be afraid to help voters with disabilities and limited English proficiency in case they fill out the form incorrectly or forget to check a box. And we shouldn't want the Attorney General aggressively prosecuting people who are just trying to help voters that might make a paperwork mistake, especially election workers. This bill does not have a carve-out for shuttle drivers, public transit workers, rideshare drivers such as Uber and Lyft. And this will deter people from wanting to drive voters to a polling location in places where public transportation is hard to access, such as Starr County. Especially for curbside voters, having access to ride to the polls is critical. We should focus on helping every eligible Texan participate and not have a consequence of making voting less accessible. Members of the committee, I urge you to vote no on this bill.
Thank you, ma'am. Members, any questions? Ms. Plessa?
Thank you so much for your testimony. So I just had a question. Does this bill potentially violate any federal ADA protections?
I think other folks may have a better testimony and background on this.
Okay.
I'm on our policy team, not our legal team.
Okay,
So I
great.
don't want to give you the wrong answer.
Thank you.
Mr. Toth?
Thank you, Mr. Chairman. So should we make opportunity available for people that have a legitimate problem walking into a booth?
They should have the ability to curbside vote.
Legitimate? That you've got a legitimate, in other words, should we have a legitimate alternative? I'm sorry, should we have a legitimate alternative for people that can't physically get into the voting booth?
Yes.
But you shouldn't have to legitimize it.
They should have access to be able to vote on election day if they choose.
Is there any, you had mentioned chronic pain, is there anything in this bill that prohibits someone from chronic pain curbside voting?
No, but they have to
There's
sign
not.
an affidavit, and if that's challenged, then
Why is
they'll
that,
have to
why is
prove
that a problem?
Because
So there's no issue then with people that take advantage of it and abuse it? Anyone should be able to do that?
there's already protections in the election code to prevent that from happening.
How?
In the way that it's written now, the bill that I'm looking at, on the sections provided, that it adds to, it already has, for like voter assistance, they already have to fill out a form. And there's currently not an affidavit that somebody has to sign if you're disabled.
Okay, but there shouldn't be any penalty for perjury then, for lying.
I'm not sure that that gets to the point of what we're trying to prevent here.
Okay.
Members, any other questions? Thank you, ma'am, for being here.
Of course.
Chair calls Marlisa Marin with Common Cause of Texas. Hello, ma'am. I show you registered as Marlisa Marin with Common Cause Texas, and you are here to testify against the bill?
Correct.
Thank you, ma'am. You may proceed.
Hello, Chair Shaheen, Vice Chair Busey, and committee members. As I've mentioned in previous testimony, my name is Marlisa Marin, and I help run the Nonpartisan Texas Election Protection Program. I'm here to testify against HB 521. During early voting last year, we received a call from a Galveston County woman who was bringing her elderly mother to vote. That caller told us that the walk into the polling place was too long for her mother last time she voted, and she wanted to know if there was a way to find polling locations that are more elderly friendly. Our hotline was able to tell this woman that her mother could use curbside voting. A Tarrant County voter with disabilities asked if poll workers could bring a machine to her car like they did last time. A Montgomery County voter told our hotline that he was too old to wait outside in the Texas heat. If HB 521 becomes law, our hotline would have to warn these voters that curbside voting now comes with the risk of perjury. We would have to ask if they really, actually can't get to the polling place without injuring themselves. Perjury is a Class A misdemeanor in Texas with up to a year in jail and a $4,000 fine if you are found guilty. If elderly people and people with disabilities are forced to sign an oath to use curbside voting, many will simply decide to try and not to go into the polling place and injure themselves just trying to vote. Others may simply choose not to vote at all. Last session, this legislature passed many bipartisan improvements to curbside voting. HB 521 would discourage voters from using a process that everyone just worked together to improve. Curbside voting helps Texas voters. Let's not make it inaccessible to them. Please don't pass HB 521. Thank you.
Thank you, ma'am. Mr. Toth?
You mentioned Montgomery County.
Yes.
I worked that parking lot in Montgomery County for the 2 weeks of early voting. And it's right near a senior assisted living facility. And a lot of those people come across the street to vote there in their cars. It's not just the heat, it's the length of time that they have to be there. Whether it's waiting in their car because other people are going to take advantage of that, they should not be made to wait. And if there's anybody that's abusing the system, they should not have the opportunity to abuse the system, which puts other people that genuinely need to do this at risk.
Members, any other question?
Was there a question?
No, it was a statement. I
Yes.
apologize. Do you think that's okay? How's that? Now it's a question.
Members, any other questions? Thank you, ma'am, for being here.
Thank you.
Chair calls Taylor Trevino with Texas Civil Rights Project. Ma'am, I show you registered as Taylor Trevino. You are with the Texas Civil Rights Project, and you are here to testify against the bill. Is that correct?
Yes.
Okay, thank you. You may proceed.
All right. Chair Shaheen, Vice Chair Busey, and members of the House Elections Committee, my name is Taylor Trevino, and I'm here representing TCRP to register our opposition to HB 521. We were opposed to the bill as filed, and unfortunately, the committee substitute does not resolve our concerns. HB 521, as has been discussed, would require curbside voters to sign an oath on penalty of perjury that they are physically unable to enter the polling place without personal assistance or likelihood of injuring their health. It will also ban the poll worker who is delivering the ballot to the curbside voter from assisting a curbside voter with marking the ballot, which I will add doesn't seem to address the main issue that was being shared earlier. Forcing a voter to swear under penalty of perjury will make them potentially subject to a Class A misdemeanor, making it scarier for voters with disabilities to use a method of voting that is supposed to make their participation in our democracy easier. More to the point, voters with disabilities or limited English proficiency are entitled to assistance with reading and marking the ballot in Texas and under federal law. Limiting a poll worker's ability to help a voter with this process will disenfranchise voters who, for whatever reason, were unable to get someone to come with them to the polling place to mark their ballot. TCRP is viscerally aware of the potential for disenfranchisement here because we are in a coalition, along with others here today, who run the Election Protection Hotline, a resource for voters to get help during every step of the elections process. During the 2024 presidential election, the highest number of calls we received from voters were because of disability access issues at the polls. To quote our report on the matter, of the 543 tickets resolved through the 866 Our Vote hotline, 163, or approximately 30%, were related to disability access issues. Giving a zealous prosecutor an avenue to prosecute a voter with a disability for not looking disabled, for example, will throw gasoline on this veritable wildfire of voter disenfranchisement. We ask the committee not to report HB 521 favorably. Thank you.
Thank you, ma'am. Members, any questions? Thank you so much for being here.
Thanks.
The chair calls Sabrina Gonzalez-Salcedo with the ARC of Texas. Hello, ma'am. I show you registered as Sabrina Gonzalez Salcedo, and you are with the ARC of Texas, and you are here to testify against the bill. Is that right?
That's correct.
Okay, great. Welcome.
Yes, thank you so much. Good afternoon, Chair and members of the committee. My name is Sabrina Gonzalez Saucedo, and I am the Director of Public Policy and Advocacy for the ARC of Texas. The ARC promotes, protects, and advocates for the human rights and self-determination of Texans with intellectual and developmental disabilities. And I appreciate the opportunity to share our concerns about House Bill 521. We really appreciate the author's intent in working with stakeholders to try to address some of our concerns about unintended consequences for voters with disabilities. And we understand that the intent of this bill is to strengthen election integrity, and we certainly share the same goal of ensuring fair and secure elections. However, we are concerned about some of the provisions in the bill that may unintentionally create new barriers for voters with disabilities, making it harder for them to exercise their right to vote or to have their vote counted. For example, House Bill 521 as written requires additional paperwork for election officers assisting voters at curbside voting. Beyond the administrative burden, it also prohibits election officers that deliver a ballot to a curbside voter from assisting the voter in marking their ballot. We also have concerns about the bill's language regarding documentation requirements and penalties. Page 3 states that a form completed under subsection A shall be delivered to the Secretary of State as soon as practicable. But without a clear timeline, this could lead to inconsistent enforcement. Additionally, the provision stating that a person commits an offense if they knowingly fail to complete the form required by subsection F creates a standard that is difficult to prove, creating criminal penalties for administrative errors, particularly for those assisting voters, could have a chilling effect, potentially discouraging people from providing assistance to voters with disabilities out of fear of legal repercussions. Texas has a responsibility to ensure elections are both secure and accessible to voters with disabilities. However, our laws have not always made that possible. Just this week, a federal court ruled that provisions of Senate Bill 1 passed in 2021 violated the Americans with Disabilities Act and Section 504 of the Rehabilitation Act by imposing unconstitutional barriers to voting for people with disabilities. Judge Javier Rodriguez of the U.S. District Court of the Western District of Texas made clear that policies restricting access to the ballot must comply with federal disability rights laws. With this in mind, we encourage the committee to carefully consider the impact of HB 21 on voters with disabilities and look for ways to strengthen the election security without creating additional burdens for those who already face significant barriers to participation. I appreciate the committee's time and consideration, and I welcome any discussion on how we can work together to ensure that all Texans have the opportunity to vote. Thank you.
Thank you, ma'am, for being here. Members, any questions? Mr. Raymond?
So have you, you may have said this, have you been involved in campaigns yourself, elections, let's say elections where you've seen kind of what's being talked about here, people being helped by being driven to the polls, curbside, all that? Have you seen that?
I have not.
You're familiar with it though, right? That's what you're testifying?
That's what I've heard from folks that have testified today.
Okay. You're against the bill, right?
Yes.
Have you talked to other people? I assume you did before you decided to come and testify. Were they informed you and about the issue?
I spoke with other disability rights stakeholders that had similar concerns about how this bill could impact voters with disabilities. I wasn't familiar before coming here today where this bill idea came from. Wasn't familiar with that, even as a resident of Hidalgo County.
You're from Hidalgo County?
Yes.
Where?
I was born in FAR, went to school in San Juan. Parents still live in FAR. I live in Austin now.
You were born in FAR, went to school in San Juan, and live in Alamo? No.
PSJ through and through.
So are you a bear, or what are you?
I went to Idea San Juan. I'm a saint.
Okay. Okay, the Saints are marched in.
Right next to the Basilica of San Juan.
Oh, well, okay, that's important. Well, we're about to talk about God, buddy. So I mean, Chairman, sorry.
I'm
We're about to talk
Valley
about
through and through.
a very important church. Very important church.
Agreed.
But I think, are you getting a sort of a flavor of what the author is trying to do here, right?
I completely understand that intent in wanting to ensure that our elections are fair and secure. And I think that, especially recently, voters with disabilities have encountered increasingly scary burdens that have kept them from going to cast their ballots and have their ballots counted. And we think that this is furthering those
Well,
burdens.
it's a balance, man, because you know, the folks that get aggressive, and you see it in all kinds of campaigns. This isn't just, believe me, this isn't just Stark County, and it's not just, you know, Tarrant County. It's everywhere where, and it's conservative candidates, Republicans, Democrats, everything, where you have, you know, supporters or volunteers or campaign workers, whatever, that get very aggressive, right, about trying to get folks to the polls, trying to encourage them to vote, obviously, for their candidates, right? I'm sure all of us, let me see, I think everybody up here, yeah, I think everybody up here has been through some really tough campaigns, right? Everybody up here. And so I'm sure you've encountered that with your opposition where, you know, they had folks that were advocating for them and trying to push for them and got very aggressive about it. And so I think that's what the chairman is trying to, Chairman Guillen is trying to get to, is how do we get to a system where, or a point where, you know, you minimize that, you know, where you minimize that, especially with the elderly, if you will, where they're not pressuring them, you know, they're not pushing them, they're not getting on them and all that. So I think that's it. I hope you recognize.
Yes, completely. And I hope that we can address that concern without infringing of the rights of voters with disabilities.
Well, right. Yes, I hear you. It just it's threading the needle. This stuff is trying to thread the needle, and I think that's what I think and believe that's what we're trying to figure out. Yeah.
Members, any other, Ms. Plaza?
Thank you so much. So you represent the ARC of Texas, right? And that's
Yes,
a disabilities rights organization, okay?
Yes.
So now I'm going to ask you this. Does this bill violate any, or potentially violate any ADA protections?
I hope that we will have a witness that will be able to come and talk to that. I personally am not a lawyer, but I can say that the state of Texas has been in hot water. As I said, I mentioned federal court's ruling that the rules that we have on the books are too onerous and create barriers that are unconstitutional for voters with disabilities to cast their ballot. And so I'm not a lawyer and not able to answer that question, but hope we have some lawyers that'll be able to speak to that.
Okay, thank you. Thank you so much. Thank you, Chairman.
You bet. Members, any other questions? Thank you, ma'am, for being here.
Thank you.
Chair calls Ed Johnson with Harris County Ballot Security and Self. Hello, sir. I show you registered as Ed Johnson, representing Harris County Ballot Security and yourself, and you are here to testify for the bill. Is that correct?
That is correct.
Welcome back, sir.
Great bill, I tell you, Representative. You know, just to set the record straight, a person that is disabled automatically qualifies for a ballot by mail. So if they're too stressed or bothered to go to a poll, they can get a ballot by mail automatically. So this is just, you know, we're referring to people that want to participate in the process, you know, in the regular process of voting, that feel that they want to come out and do this. And that's who we're talking about. And we should try to protect their rights to do this. And I think this bill does it. Give you an example, in Harris County, in one of the primary elections, you had long lines, you know, to go vote when I was working down there, and you had a radio station that got on and said, "Hey, y'all can cut in line by going up and asking for a curbside voting." And you know, we had polling locations in the neighborhood of this radio station where cars were lined up, honking their horns, wanting to come out and curbside vote. This is keeping handicapped people from voting. These are people abusing the system. I don't think a handicapped person would have a problem with signing a statement saying that I'm not able to go into the poll if they're truly, you know, that way. They should be able to give them that right and not let people take advantage of this situation. We've, you know, had other campaigns that have sent you know, people into polling locations trying to ask for curbside voting, because I will tell you, curbside voting actually slows down the voting process tremendously, because it takes 2 workers to take the machine out to the car, and it probably takes, you know, 10 times longer for someone to curbside vote than it is to just regular vote. So by trying to fraud the system, you're also disenfranchising voters that are trying to vote inside, because it just slows the whole process down. And this would make it to where handicapped people could get access to that curbside voting really accessibly, and then be able to participate in the process like they want to.
Thank you, sir. Members, any question? Ms. Plessa?
Thank you so much for your testimony. So I just have a question. How does requiring a disabled person, let's say a person that has Parkinson's, right? We're requiring this person to sign an affidavit under perjury. How is that helping disabled people have more access to the ballot box?
Well, I would hope that the people listening to that radio station that were not disabled
Well, we're
lined
not
up-
talking about
No,
the
not-
radio
well, let me
station.
answer
What
your
I'm
question.
asking about, that's one situation, a one-time thing. This is not going to be a one-time thing. This is going to be a forever thing. And in my district, in my experience, what I've been seeing is a bunch of people that have the right to access curbside voting that aren't using it because of whatever reason. They don't want to disclose that they have a disability. They don't want to take up space for someone else that has a greater disability for them. So I guess my question to you once again is, we're going to be requiring, and I'm going to use the example of Parkinson's, because this is somebody that's hands are probably shaky, their signatures probably now aren't going to match up to their current ID or whatever, and we're saying under perjury of law, right, that how is that not an undue burden that is not on an able-bodied person? And how does that not disenfranchise disabled people from voting more?
Okay, can I answer your question?
Yes, but
Okay.
don't talk about the
Well,
radio station.
I'm going to talk about people that are trying to abuse the system. And hopefully, by them having to fill out this application and possibly committing perjury, they will not abuse the system and give this person with Parkinson an ability to use the system. The person with Parkinson is not committing perjury. They're not committing an offense. Why wouldn't they mark it? Now, then there are all kind of already exceptions in the code for if they cannot properly do their signature like today, all they have to do is make a mark on here affirming this. Or someone can assist them in marking it. So that is all in the voter assistance.
Someone can assist them
Yes.
now?
Yes, and if they go with the voter assistance module in the election code, they can come and take the oath to be an assistant and assist the voter. So there is no reason that this person with Parkinson is going to have any problem with this oath. But it hopefully will keep the people that are trying to abuse the system and keep this person from Parkinson from voting out of the line. Because when you get people lined up to that curbside voting, it may take hours before you can get the curbside voting out there. Our polling locations usually only have one curbside unit, and it takes a long time to prepare that curbside vote to bring it out. So if you have people abusing the system, you're keeping people that really need this service from being able to access it.
Okay, thank you.
Members, any other questions? Thank you, sir, for being here.
Thank
Chair
you.
calls Catherine Kano, representing herself. Chair calls Bill Sargent, representing himself. Hello, sir. I show you registered as Bill Sargent. You are representing yourself, and you are here to testify against the bill. Is that
Well,
correct?
that depends on what I hear. I have a question.
Sir?
Yeah, I
would
am
you-
Bill Sargent. I'm the former Chief Deputy Clerk of Elections for Galveston County. I'm on record as opposing the bill, but I might want to change that depending on the answer to the question I'm about to ask.
Okay, but hold on, sir. So I need to confirm publicly how you're currently registered.
Currently registered as against.
Okay, so let me just read what I have on my screen as dictated how you registered, and I'll still need you to confirm it. I apologize, but
No
there's
problem.
rules that we have to follow in the House. So I show you registered as Bill Sargent. You're representing yourself. You're currently against the bill. Is that correct? Okay, thank you, sir. I apologize.
No
Go
problem.
ahead.
The question I have is, as I read the bill, it indicates that people who are poll workers who take the equipment out to the pole, to the curbside, are not allowed to assist the voter. If that's true, I would oppose the bill, because that's, we can do that inside a polling location, and as long as you have two people out there, you have integrity of nobody swaying somebody one way or another. But if indeed that is the case, then I would oppose the bill. If indeed is the case, that's not the case, then I would support it. So I don't know the answer to that question. As I read it, it said, the poll workers could not assist the person out there, having already taken an oath inside before you start working. So as long as I've been a judge as well as running the elections in Galveston County, all poll workers have taken an oath and are allowed to assist any voter who wants assistance. So if I have an answer to that question, I would.
We're thankful that you came to testify. What I would suggest you do is meet with the bill author or their staff to get clarity on your question.
Is
and
the
then
author
you can
here?
make a determination. That's Representative
which way
Guillen
is it?
right there. And so what I would suggest, sir, is after the committee hearing is over, that you either email Mr. Guillen's office or call them, and you can get the clarification that they need. And my guess is they'd be willing to sit down and meet with you as well.
Okay, so why don't we change it to on the bill as opposed to opposed to it, because I don't have the answer to that question. Can we do that?
Yes, we will update your registration to show that you are testifying on the bill.
Correct.
Yes,
Thank you, sir.
You bet.
Thank you,
Thanks
Mr. Chairman.
for working with
God
us.
bless you.
Yes, sir. Thank you for being here. Oh,
I'm sorry, was there a question? I'm sorry, forgive me.
So I just want to get clarification
Chair
on what you were
recognizes
saying.
Ms.
Sure.
Plessa.
Thank you, Chairman.
Forgive
I
me.
appreciate that.
I've got to go back over to the sentence, so
So
forgive me.
basically, what you're saying is that when someone brings the polling, the machine out,
Right.
they cannot. What you're saying is that they cannot help the person, mark their machine.
My understanding is that's what the bill calls for. I would not want that to be the case.
Right, but then if I'm inside and let's say I'm half shaking hands or whatever, inside they could help me.
Absolutely, it's according to the law.
Our fear is that this might be creating some kind of catch-22 for disabled voters
Well,
who need assistance outside with the voting machine.
and the bottom, having run the elections for a long time, I can tell you that our whole purpose is to help people vote. All right. So, to the extent that inside a polling location, as long as you have two people there, one from each party, you can help that person. The same things should be true out at the car.
Okay, thank you. I just wanted
Sure.
some clarification
I'm sorry
on
for
the
running out on
difference
you. Forgive
between
me.
the two. No, it's okay.
Okay.
I appreciate your time. Thank you so much, sir. Thank you, Chairman.
You bet. Any other questions, members? Thank you, sir,
I'm
for
off to
being
the
here.
Senate.
We
See you later.
appreciate it. Yes, sir. Thank you for being here. Chair calls Chase Bearden with the Coalition of Texans with Disabilities and yourself. You can go right there.
If you come over here, sir, I have a lower one for you.
Okay.
I think so.
And I show you, sir, as registered as Chase Bearden, and you're with the Coalition of Texans with Disability, and you're also representing yourself, and you're neutral on the bill.
Yes.
Okay, thanks for being here, sir. You may
Thank you,
continue.
Chairman, Committee. Appreciate the time to speak on this. And we want to thank Representative Guillen and his staff for working with us over the last day to try and address some of the issues. We do see some possible unintended consequences. And kind of to start with, in the oath that they've added in here from the original version to the committee sub, it changed to requesting to vote outside. It should be requesting to vote curbside. That way it's matching the same language throughout the curbside voting. I think the gentleman that just spoke, there is some clarification there, and I think that's where some confusion has come in, where it says that the person that brings out the ballot can't help assist you. When you get assistance on the inside, helping use the machine or whatever you needed, typically there would be 2 people there. If you were asking for one of the election officials or workers to help you, they would have someone from both parties. In curbside, sometimes there's only one person that comes out. So I understand what they're trying to do there. Now, if that person is only delivering the ballot and you're just not getting out of the car, but you're actually doing it yourself without other assistance, that's where we wanted to make sure there was some clarification. Because at the moment that you finish filling it out and the ballot prints, that person takes it back in and then puts it in that tabulator. Is that considered assistance? Because we are asking that poll worker to, if they assist you, to have to fill out a form and take that oath. Just like for me, if I'm inside the building, I've cast my ballot, it's printed out my ballot, I've looked at it and confirmed it. As I'm rolling out the door to put it in the tabulator, I'm too short, I can't reach it. So more than once, I've had someone from that's working there ask if they want me to put it in the top for me. You know, typically that wouldn't have been assistance and you wouldn't have had to sign for that. But that would be completing the ballot process. And we just want to make sure that the poll worker doesn't end up, you know, not thinking about it. They're just taking it back in, doing what you're saying, or putting it in the machine, and ending up with a Class A misdemeanor. You know, clarifying what that assistance is, if they're taking it back in, clarifying the outside versus curbside is something that we want to make sure is done. Also, where it does say a person who, during early voting period on election day, it used to be simultaneously took 7 people. The question we have there is when you take out simultaneously and it's just 7 people, I think one of the groups that, I don't know if it would just need to be education or how this would be handled, would be like in your bigger cities where you have paratransit, which they specifically pick up and drop off people with disabilities that can't use the regular bus system. So they very specifically could possibly drop off 7 people, 8 people over a stretch of time, not meaning to drop them off there, but that's because that's how they get the ride. How would that bus driver know that they needed to sign a form? You know, just making sure if that's the case, let's spell it out and make it very clear on who and why, because I don't want to end up forcing someone that, you know, was just a driver and didn't really realize that dropping someone off at a certain location was going to affect them.
Thank you for pointing those out. I think those are very valuable. Have you worked with the bill author in his office?
We've
Okay.
been working with Matt and Representative Guillen's office. So
Okay.
Yeah.
Great. Your assistance is very helpful
Thank
in
you.
that manner. Members, any other questions? Thank you, sir, for being here, and thanks
Thank
for
you.
your past work with this committee on these issues. Chair calls Molly Broadway with Disability Rights Texas. Hello, ma'am. I show you registered as Molly Broadway. You're with Disability Rights Texas, and you are neutral on the bill.
Yes.
Okay, well, welcome. Thanks
Hi.
for being here.
Thank you. I just wanted to say, I know there's been a lot of questions coming up about how this bill may affect those with disabilities, the disability community, and I wanted to make myself available to that. I am my official title is Training and Technical Support Specialist for Voting Rights. I've been in this position for 10 years. I cover the entire state of Texas. We help run a statewide hotline regarding voter rights, which is especially busy during voting season, but open year-round. We partner with all the other advocacy groups related to voting rights. We serve with election protection on handling hotline calls as well when disability issues come up. So if y'all have any questions, I'm happy to try to answer those.
Thank you for being here as a resource. Members, Ms. Plesa?
I'm just going to ask you, because I still haven't gotten a clear answer on this. Does this bill violate any federal ADA protections?
My concern about this bill is, and I know that there is language probably needs to be clarified and refined on it, but my initial concern, I'll tell you as a person just reading the bill, and my concern is if you're reading the election code. And this bill came up saying that the person who gave you the ballot, if you're doing curbside and the person who gave you the ballot, they cannot provide assistance even though you requested it. That person who's providing you the ballot cannot assist you. My concern is that that would be a denial of an accommodation request, which goes against the ADA and what the county must provide to voters with disabilities.
Thank you.
Yes.
Members, any other questions? Thank you, ma'am, for
I
being here.
would like to say a couple other things. There's been comments made about the value of this bill because people have gone to assist those who have requested curbside services, voting services, and it's been reported that poll workers have looked at those voters and assessed on their own virtue that that individual was not disabled. I think, first of all, it's not the role of the election worker to make that decision. Nobody can make a decision based on one's appearance, whether or not somebody has a disability or not. I think we're all familiar with the idea of invisible disabilities and what we cannot see. We all are related to people who probably have disabilities, if not ourselves, that you cannot see. So it is not the role of the poll worker, and that has been decided through litigation already. Also, in concern of why wouldn't voters, and not handicapped voters, voters with disabilities, why wouldn't they be okay with signing the affidavit that is proposed? First of all, it's a violation of HIPAA to even have to disclose what your disability is. We are not required to ask that. Individuals aren't required to ask that when they ask for accommodations at work. They don't ask for the specific need of what's causing those accommodations requests. They don't ask for that at universities. They shouldn't ask for it here. And I would just urge you to think about you as an individual having to verify your request for everything you've made for everything in your life. How would you like to fill out an affidavit every time you requested help for something? Because somebody didn't think you looked a certain way, or you didn't need the help that you actually knew that you needed. Because it's been proven through litigation that poll workers are not the defining source of who has or who does not have a disability. It is that individual. They have been deemed the most appropriate person to tell you what they need.
Thank you, ma'am.
Yeah.
Is there anyone else that wishes to testify on, for, or against House Bill 521 and its committee sub? If not, the chair recognizes Chair Guillen to close on the bill.
Thank you, Mr. Chairman. We're working with everybody, and we're working on a sub, and we'll get something to you all as soon as we can. Try to work with everybody and come up with a good product.
Sounds good. Thank you, Chair Guillen. The committee substitute is Dawn. I'm sorry, Mr. Raymond.
Just one, I wonder if, as a compromise, we could bracket this to Stark County. Would that be a good compromise?
No, sir. And let me, now that you mention it, this, of course, is not isolated to Stark County. Just recently, there was a case in Hidalgo County, and it was widely publicized in the newspaper, the trial and everything that happened, and so a lot of us were able to kind of follow what was going on. But in Sullivan City, which is in Hidalgo County, it was reported that at that trial that somewhere over half, near half, something at about half of the voters that voted in Sullivan City had either voted curbside or had assistance or both. And so and then the election was overturned and handed to somebody else. In fact, I think in that case, and even another case in Hidalgo County. But it just points to that there's an issue. Not only is it curbside voting, it's the assisting, whether it's at curbside or not, or whatever, and that's what the bill tries to get to, both at curbside and with assistance. And, you know, it's not easy to come up with the right language, and I'm glad that, and so we filed a bill that did everything that we thought we could throw in there, and hoped that people would come to us and talk to us about their concerns, and then we could, you know, massage it out, but they didn't come till yesterday. So, you know, as as it's usually done, I guess. So we'll take the time and we'll try to get something as soon as possible.
So is that a no?
That's a no.
Ms. Plesa?
And Chairman, I really respect the integrity of this bill and what you're trying to do. And like, I agree with Representative Raymond, you know, we want to make sure that the right people are voting the right way. And so, you know, what I would like to do with you next session is to make sure, you know, to deal with the real problem, I guess, that what I'm seeing is that too many polling places in Texas aren't ADA, you know, compliant, right? So our disabled communities are having a hard time getting into the polling place and voting. And so maybe totally respect the intent of this bill, but would love to work with you on a bill next session to make sure that we can actually get people with disabilities into a polling place and voting in person, not at the curbside.
And no question, there was I was just talking to Tony this morning about an instance in Starr County last time where, you know, she was working one of the polling places, and so many people were voting curbside that the line started to back up, and it was taking hours to vote. And, you know, the assumption is that not everybody is really eligible to vote curbside, but technically we don't know, right? Because we can't ask. And so we're just trying to get we're trying to find a solution to address the issue. And of course, at the root of it, as many have come up and said today, is that we want to make sure that the polls are open for everyone, particularly for those that are disabled, and we want to make sure that they don't have to, you know, wait 2 or 3 hours to vote when they shouldn't have to. Yes.
Absolutely,
so
Chairman.
I want to work with you too.
Yeah, no, and I totally respect the intent of this bill and totally agree with you that we don't want people abusing the system, especially when they should be going inside and voting in person. And so I just wanted to say thank you so much for that, and I would love to work with you to kind of expand on this next session to make sure that, you know, our polling places are ADA compliant and that people can go in and have their voice heard inside where there's air conditioning. Thank you, Chairman.
You bet. All right, the committee substitute is withdrawn. If there's no objection, the bill will be left pending. Is there objection? The chair has none. The bill is left pending. Stay right there. Chair lays out House Bill 242. Recognizes Chair Guillen to explain the bill.
Thank you, Mr. Chairman. Members, Article 6, Section 4.
I'm sorry to interrupt you. I'm going to offer the chair offers a committee substitute for this bill.
Thank you, Mr. Chairman. Article 6, Section 4 of the Texas Constitution states, in all elections, quote, in all elections by the people, the vote shall be by ballot, and the legislature shall make such other regulations as may be necessary to preserve the purity of the ballot box, end quote. Members, the integrity of our elections depends on ensuring that every Texan can vote freely and with the assurance that their ballot selections remain private and free from coercion, intimidation, and the misuse of their voting choices. Members, in that spirit, we filed HB 242 and the committee substitute to HB 242 to create a criminal offense for individuals that attempt to and actually unseal a person's ballot, with limited protections for elections officials and court actions. Based upon stakeholder feedback, we now bring you the committee substitute, which removes the attempt to component, but retains the creation of a criminal offense for obtaining personally identifiable voter information that connects a voter to their ballot selections in violation of their right to a secret ballot. The bill differs from the sub as it applies only to offenses committed on or after the effective date, ensuring that existing cases are handled under current law while providing clear protections moving forward. We also broaden protections for election officials and for court-ordered actions. Additionally, committee substitute to House Bill 242 with the requester's consent or decision from the Attorney General, we allow county election officials to further strengthen voter privacy protections by making election-related information confidential. Specifically, it ensures that records such as early voting rosters, polling place identifiers, ballot images, and chain of custody documents could be redacted if publishing them would compromise the secrecy of a voter's ballot, and only if. Members, the right to a private ballot is enshrined in our state's constitution. Committee substitute to House Bill 242 ensures that Texans can cast their votes with confidence, knowing their choices will remain private and protected under the law. We are working on refining some language again, also on this bill, and we'll get you another sub as soon as possible. And I'll answer any questions if y'all have any.
Thank you, Chair Guillen. Members, any questions? All right, Mr. Guillen.
Thank you.
We'll recognize your right to close.
Appreciate it.
We will proceed to testimony. The chair calls Ms. Shannon Ayers, Citizens Defending Freedom, and yourself. Hello, ma'am. I show you registered as Shannon Ayers, and you are with Citizens Defending Freedom, and you are also representing yourself, and you are here to testify against the bill. Is that accurate?
Correct.
Okay, thanks for being here. You may proceed.
My name is Shannon Ayers, and I'm with Citizens Defending Freedom, and I'm speaking against House Bill 242 today. After every election, CDF's State Elections Director, Debbie Lindstrom, personally collects and analyzes election data. She requests public records to verify election accuracy. This is how we protect our voice. Under this bill, she could face a third-degree felony if any documents inadvertently contained information connecting voters to their ballots. 10 years in prison, the same as someone who commits a drive-by shooting, for trying to ensure election integrity. This bill silences our voice. The price of liberty is eternal vigilance. These words have guided our constitutional republic for generations. But HB 242 tells citizens that vigilance now comes with a prison sentence. This threatens our voice. This bill criminalizes the very transparency we need for secure elections. It contains no requirement that someone knowingly obtain this information. A citizen auditor could face felony charges for possessing documents they had no idea contained protected information. This eliminates our voice. The bill provides exceptions only for election officials and court proceedings, leaving ordinary citizens completely exposed. This isn't just a technical problem, it's the bill's fundamental purpose. This suppresses our voice. As Thomas Jefferson said, when government fears the people, there is liberty. When the people fear the government, there is tyranny. This bill would make people fear participating in basic election oversight. This weakens our voice. In Texas, according to Article 6, Section 4 of our state constitution, elections are by the people. And as someone who represents the voice of the people and who hears from citizens across the state, I can tell you that citizens want transparency and they want auditability in their elections. This is how we honor our voice. This isn't a bill that needs amending, it's a bill that needs defeating. For Debbie, for every Texan who collects and analyzes election data, and for the integrity of our elections, I urge you to reject House Bill 242, because in a constitutional republic, the people's voice matters. Thank you.
Thank you, ma'am. Members, any questions for the witness? Thank you, ma'am, for being here. Chair calls Susan Valiant, representing yourself, SREC SD10, Texas First Election. Hello, ma'am. I show you you're registered as Susan Valiant. You're here testifying on behalf of yourself, SREC SD10, Texas First Elections, and you are here to testify against the bill.
Yes, sir. Yes,
Okay,
Chairman.
thank you for
Yes,
being
thank
here.
you. And I appreciate Representative Gillian for making the substitution, because as it stands right now, I would be in jail right now. Because we did, and it was just by pure accident that we fell on the secrecy of the ballot because of the countywide polling place program. You can eliminate, or actually you can, it's like the process of elimination is what it's called, so that you can have one precinct in the whole polling location that is from just one precinct, and so you can pull out their ballots. And like I said, it just was completely by accident that we even discovered that in the first place. And then, of course, we want to go ahead and be able to tell our reps you know, that this is occurring and that we can find this information out. And we wouldn't be able to do that. We'd be prosecuted and wouldn't be able to tell you that information in order to get it fixed. Because that's one of the issues that have that and the small number in the counties, the small precincts, those can also be identified too, but we're talking about 6% of the countywide polling place program in each one of the counties is actually vulnerable to having those. And I did all 96 counties that participated in 2022, and we came up with 117,000 ballots that we could identify. And so that's kind of that's something we could eliminate by getting rid of the countywide, but that's something that y'all need to know, and we wouldn't be able to find that out to give that information to you if we were being prosecuted beforehand. I would appreciate it, though, if instead of just the attempt of it or the obtaining of it, be changed to the publishing of it. And I appreciate, and I hope that you vote against this unless they change that part.
Thank you, ma'am.
Thank you.
Members, any questions? Yes, Mr. Ramey?
Tell me again who you're
Susan Valiant. I'm from Tarrant County, and we did Tarrant counties. I'm SD10, Field
What?
Kings,
What?
SREC, SD10.
What's the R for?
The State Republican Executive
And you're
Committee.
against this?
And
You're
I'm-
against this bill?
And I'm against this bill as it's written right now, but I'm getting a little more for it with the substitutions, if we could do publishing instead of
So it's
just
too-
the
is it
obtaining.
It's too liberal right now, or what?
No. Yes. But just obtaining, because like I said,
What
we
about
just happened to
the
follow
SREC? Is that what it's called?
SREC, yes.
From down in where he's from. How are they for it, or do you know? Did you ask them?
Tarrant County, what county are you from? Starr County. Oh, there you go, Tony.
Is she the SREC?
Yes,
Is she
yes.
for it? Do you know if she's for it?
And she is, yeah. I mean, you're against it too, aren't you?
You can't. Don't get him in trouble.
She hasn't-
Don't give us.
Sorry.
Don't give us a point of order.
Pardon me.
Never mind.
Sorry. Trying to get me in trouble.
Any other questions, members, before we lose control? Thank you, ma'am, for being
Thank
here.
you.
Chair calls Evan Preston with Secure Democracy USA. Hello, sir. I show you registered as Evan Preston with Secure Democracy USA, and you are here to testify for the bill.
That's correct.
Okay, thank you, sir, for being here. You may continue.
Thank you, Mr. Chairman. Want to share that I'm Evan Preston, Senior Director of Advocacy with Secure Democracy USA, and we're a nonpartisan group working to build stronger elections state by state. I want to thank Chair Guillen for his leadership with this bill to ensure ballot privacy for all voters. In 2023, Texas lawmakers passed HB 5180, which took bold steps to increase election transparency, but under that new law, it became possible to link specific ballots with individual voters, especially, as has been mentioned, in smaller and rural precincts. And this jeopardizes voters' right to a secret ballot. So last year, the Secretary of State and the Attorney General issued emergency guidance, which this law would codify, enabling election officials to take the steps that are necessary to protect voters' privacy. It will also allow for responding to public information requests to be clearer to the election officials for how they should handle those. And that's a proactive and efficient solution to prevent, on the front end, from allowing for any compromises of voters' privacy. So I want to thank the chairman for his work in this bill and preventing any potential compromises of voter privacy.
Thank you, Mr. Preston. Members, any questions? Thank you, sir. Chair calls Terry Putnam, representing yourself. Hello, sir. I show you registered as Terry Putnam, and you are representing yourself, and you are here to testify against the bill. Is that accurate?
That's correct. And thank you, Chairman and members. I want to make just a few points. This bill could be used against any private citizen who inadvertently is given personally identifiable information. So they could be charged criminally under this bill. Number two, this bill seems to fly in the face of transparency, particularly against ordinary citizens, because that seems who this is aimed at, is ordinary citizens, the people who like to look at the voter registration, look at the election results. I've been doing this for a number of years, my personal PIA request, I always say, I am not asking for any personally identifying information. That's on my request. So I shouldn't get it, but there's no guarantee that I won't get something. We just heard a partial quotation from the Texas Constitution. Let me read you the rest of it. The legislature shall provide for the numbering of tickets and make such other regulations as may be necessary to detect and punish fraud and preserve the purity of the ballot box. The legislature has done that. They have passed legislation that says preserve the purity, the secrecy of the ballot. In that same section, it says the election shall be auditable. So this information that people request about the elections is how citizens audit the elections. So this bill seems to put a damper on that and threatens people with a criminal offense, maybe through no reason of their own. So that concludes my testimony. Thank you, Mr. Chairman.
Yes, thank you, sir, for being here. Members, any questions? Thank you, sir, very much. Chair calls Jennifer Doinoff, Texas Association of County Election Officials, and herself. Ma'am, I show you as registered as Jennifer Doinoff, and you are representing Texas Association of County Elected Officials and yourself, and you are here to testify for the bill.
That's correct.
That's great. Thank you. You may proceed.
Thank you. I appreciate the opportunity to address you today. I am the legislative chair for the Texas Association of County Election Officials and also the election administrator for Hays County for just under 10 years now. And I just want to give you a little bit of my experience in elections before I move on to my testimony on this bill. Prior to that, I worked for a county commissioner for 11 years, of which I worked also as a presiding judge in a polling location during that time when he was not on the ballot. I also was elected to the Board of Trustees for the Wimberley ISD for 5 years, 2 of which I was elected through an election as the board president. I say this only to exhibit my broad view of elections from many different angles. On House Bill 342, we think, we're on 242, ballot privacy. I missed 342. Ballot privacy is a priority of our association membership, and we appreciate the efforts of this bill to hold folks accountable that utilize public information to obtain personal vote choices. Our Constitution does provide for the ballot secrecy, and election officials of our association want to ensure that all voters can be confident that their vote choices remain private. Thank you for the bill, Representative Guillen. We do understand that there's some modified language to the bill, and we are in support of this bill. We also want to make sure that you know and the folks in the audience know that this is not a countywide polling place program problem. This is a problem that's been identified for a long time, and there are many ways to get a hold of this information and put the puzzle pieces together, as I think this group has learned, but it's not related to countywide polling place.
Thank you, ma'am.
You're welcome.
Any questions, members? Thank you, ma'am, very much for being
Thank
here.
you.
Chair calls Dr. Laura Presley with True Texas Elections. Hello, ma'am. I show you registered as Dr. Laura Presley. You are with True Texas Elections, and you are here to testify against the bill.
Yes, sir.
Okay,
Thank you.
You may proceed.
Okay. While this bill's intent to preserve the secrecy of ballots is admirable, it misses the mark. It does not address the real reasons for the recent ballot secrecy breaches in Texas. First of all, I want to say federal and state laws require ballot secrecy and auditability. Federal law requires secrecy and auditability. No one should have access or knowledge of how people vote, even election administrators, even their employees or their agents. They should not know either. No one should know how people vote. The laws in Texas and federal laws require, again, that the voting systems and the processes must preserve the ballot secrecy. Most concerning, this bill concedes that election systems and processes in Texas do not preserve ballot secrecy. They're given an exception for the elections administrators and their employees to know it. We can't know it as auditors, but they are allowed to. That is not the law. We have to be able to audit and have a secret ballot. The problem is that there are systems, voting systems and voting locations where that allows the secrecy to be breached. And I've given you this, which gives you the 3 areas where the secrecy is breached. The countywide does, as designed, allow the breaches of 2 to 5% of voters. Early voting allows the breaches of 1 to 3% of voters. That is a fact. If we did not have the onesie-twosie voters from a ballot style at the location, you would not have the breach. You would not have the Rinaldi breach. You would not have the breach of several of you on this dais. Either your vote or your family's vote has been breached. And if we if we shut down countywide, shut down early vote, that would not happen. Even the election administrators would not have that access. The other issue that is in federal court right now, and I'm going to give you our the latest brief of that case, and it outlines what needs to be corrected for the unique identifier breach that's in the state of Texas. Okay? And that's because of waivers of election law by the Secretary of State and counties. And this brief outlines what needs to be done to correct that. You don't need to criminalize the victims. This bill criminalizes the victims for pointing out that the elections cannot be auditable, and it destroys the detection of fraud. This bill violates the Constitution of Texas and, I believe, federal law.
Thank you, ma'am. Members, any questions?
And
Thank
I will
you,
hand
ma'am.
y'all this brief.
Thank you, ma'am, for being here.
Do you have a question? Do what?
Chair calls.
Yes.
Chair calls. Chair calls Laura Rogers, County and District Clerks Association, and self. Hello, ma'am. I show you registered as Laura Rogers. You are here representing County and District Clerks Association and yourself, and you are here to testify for the bill.
That's correct.
Okay, thank you. Please
Thank
continue.
My name is Laura Rogers, and I'm the County and District Clerk for Sherman County. I'm also the Legislative Chair for Elections for the County and District Clerks Association, and I am here in support of this bill. The County and District Clerks Association supports the fundamental principle that guarantees individuals can vote freely without fear that their vote or other identifying information will be exposed. I want to reiterate, this is not a countywide problem. I am precinct-based in my county. Ballot privacy is an issue for us in every election. We're very small. It's not uncommon for us to mail out 1 or 2 mail ballots that are all the same, have precincts that have voted all the same, and so precinct-based voting has the same ballot privacy concerns as a countywide county does. I also want to point out that every election that we have is audited, and if we weren't able to audit those elections, then it would have become a problem long ago. We audit every single election. This bill has some additional language to it that we're still reviewing, but I don't feel like that language is going to be anything that will give us any kind of concern. And I thank you and would take any questions.
Thank you, ma'am, very much. Members, any questions? Thank you so much for being here.
Thank you.
Chair calls Ed Johnson with Harris County Ballot Security and Self. Chair calls Catherine Cano, representing herself. Members, would anybody want a resource witness? Okay. Is there anyone else who wishes to testify on, for, or against House Bill 242 and its committee sub? If not, the chair recognizes Chair Guillen to close on the bill.
Thank you, Mr. Chairman. Again, we're working on refining some language, and we'll work with all parties and get you a sub back as soon as possible, and appreciate your favorable consideration.
Thank you, Chairman. Members, any questions? Committee substitute is withdrawn, and if there's no objection, the bill will be left pending. Is there objection? The chair hears none. The bill is left pending.
The chair lays out House Bill 493 and recognizes Chairman Shaheen to explain the bill.
Thank you, Vice Chair Busey and members of the committee. House Bill 493 seeks to make an individual ineligible to serve as an election poll watcher if they have been convicted of a felony. Our elections are sacred, and integrity in our election process is vital. However, even though many jobs are not available to those convicted of a felony, a person can be a poll watcher in Texas with a felony conviction. Jobs not available to those convicted of a felony include peace officers or other law enforcement, emergency medical personnel, any jobs in our schools, serve on a jury, and many more. I certainly believe in redemption. However, it is reasonable to withhold certain responsibility from individuals who have made poor decisions. This legislation was voted out of committee in the 88th legislative session, was passed out of the House, where it died in the Senate. I'm happy to take any questions, Mr. Vice Chair, and reserve my right to close.
Members, any questions? If there are no further questions, we will proceed to testimony. The chair calls Dr. Laura Presley. We show you registered as Dr. Laura Presley on behalf of the True Texas Elections LLC, and you are neutral on the bill. Is that correct?
Yes, sir.
You may proceed.
Thank you. Dr. Laura Presley, and I have trained over 1,000 election watchers around the state over the last 9 years. After we hit about 1,200, I stopped counting. And I have debriefed many of these watchers. One of the things that concern me about the bill is that it says that if there's any offense in connection with conduct directly attributable to an election. I'm going to give you an example. It's a Class C misdemeanor for you to put your 4x8s in the right-of-way. And if any of you or any candidate was convicted of a Class C misdemeanor, you can never be a watcher, ever. So I think that's my concern. I'm okay with the felony stuff. And I know Representative Shaheen has brought this up in many sessions, and the original language of the bill, the original language of the law includes that offense in connection with the conduct directly attributable to an election. I would like to offer potentially an amendment to remove that so that Class C misdemeanor people can still be watchers and maybe just highlight the felony component of it. So I just want to plant that seed and let you think about it, because everybody's got their 4x8s in a right-of-way. I know y'all do. So I've seen them.
I've never done that.
Never. Come on.
Members, any questions?
Yeah.
Thank you.
Okay, bless y'all. Thanks.
Next up, we have Ed Johnson. I don't see him in the room. Ed Johnson. What did I say? Are you second? Okay. Next up, we have Catherine Cano. Catherine Cano. Yeah. Yeah. Sorry. Is there anyone else who wishes to testify on for or against House Bill 493? If not, the chair recognizes Chairman Shaheen to close on the bill.
Thank you, Chair Busey. Members, I will work with Dr. Presley and see if we can address her concerns. Otherwise, I close. Thank you.
Members, any questions? Thank you, Mr. Chairman.
Thank you, members.
Thank you, Chairman Shaheen. If there is no objection, the bill will be left pending. Is there objection? The chair hears none, and the bill is left pending. Members, that concludes today's agenda. Is there any further business for the committee to address? If not, the chair moves to adjourn. Is there objection? Hearing none, the Elections Committee stands adjourned, subject to the call of the chair.